ಬರ್ತಿದ್ದೀರಾ ಸರ್ ನಂಬರ್ ಚೇಂಬರ್ ಮಾಡ್ಕೊಳ್ಳಿ
6:27 output 26
ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ list number 2 leave the clear. List number 2 and 3 will be repeated next week. Next Friday.
List number 1 for adjournments. Page number 9.
You wanted 2/3. What is the stage of the suit? ಅನ್ನೇದು
ರಿಮೈನಿಂಗ್ ಅಮೌಂಟ್
ಹೆಂಗಾಗತ್ತೆ? Whatever money you have paid, you will lose. That you cannot get back. That's all that I have done. The money that you have paid, you have lost. The remaining they will pay and then recover from you. Being joint and several ಹೆಂಗಾಗತ್ತೆ? It is a breach of a policy condition. They are entitled to recover. Full bench says policy conditions breached. Only remedy is to recover. Pay and recover. Since you already paid some amount, you lose that money. Balance they'll pay. What is it that I can do? If the policy condition violation is a policy condition violation. It can, that is the only defense available to it, that the policy conditions have been breached. How can it not take that contention? Supreme Court.
for adjournments. Page number 9, seal number 38 and 39.
Serial number 38, my lord.
Yes.
There is one more connected CP number 431/24, my lord.
ಎಷ್ಟು ಹಾಕಿದ್ದಾರೆ ಸಿಪಿಗಳು?
ಅದು 3 CP ಆಗುತ್ತೆ, ಇಲ್ಲಿ 2 ಬಂದಿದೆ. ಇನ್ನು ಒಂದು CP 431/24.
ಅಷ್ಟು ನಾನು
ಮಂಡ್ಯ ಮೇಲೆ ಪ್ರೊಜೆಕ್ಟ್ ಇಟ್ಕೊಂಡು ಡಿಸ್ಕೌಂಟ್.
Third.
My lord, serial number 31. Senior is unable to get.
Hello. 431/24. Please wait, orders you can't move.
Page number 10, seal number 40 to 46.
42, my lord. We are trying to settle the matter. Vacation ಹಾಕಿದ್ದೀನಿ. Other side. I have given some proposal. Proposal ಕೊಟ್ಟಿದ್ದೀನಿ. No.
6.
ಯಾವುದು serial number?
42.
Page number 13. Page number 11, seal number 47. Page number 12, seal number 48.
58.
Page number 13, seal number 49 to 51.
49, your lordship, my friend.
Serial number 51.
I have informed the other side, Gunjan.
51.
Please, my lord. See, some personal inconvenience, my lord. Kindly have it next week.
Page number 14, seal number 52 to 56.
52, my lord. Yesterday I filed the notice of appeal.
ನೀವು ಯಾರಿಗೆ?
Petitioner.
List.
6th for fresh time.
My lord, serial number 56, my lord. 53, my lord. I seek for a week adjournment.
56, my lord. I am for the petitioner. 56, my lord.
58.
55. Week's time.
55.
56. Interim order may kindly be extended.
List.
55. 55.
Page
Serial number 57, my lord. I am for the petitioner. Only I have attend Monday, my lord. Senior is out of station today.
58 and 59.
58, your Serial 58 record ಬರ್ಬೇಕು.
In 58 ಏನು?
Just record ಬರ್ಬೇಕಾಯ್ತು.
Serial number 59, signed for the petitioner. Give a short accommodation. Hearing order has to be extended.
Page number 16, page number 60 to 63.
Instructed notes that Mr. Gautam Madhavan, see the notes you are correct today, we filing it for respondent number 4 to 10.
List.
Serial number 61, my lord.
Yes.
Record is called for and I need to have certain copies. Next week or week after next.
List.
Page number 17, serial number 64 to 68.
List.
Page number,
Video conference ಬೇರೆ ಮಾಡಿ.
serial number 69 to 71.
Serial number 71, my lord. I am for the petitioner. Some inconvenience.
2012.
Yes, Lord. I agree, Lord. My lords may have this matter on Monday itself. I have not. But the only problem is, Lord, so today afternoon there is a partnered matter. That's the reason.
List.
Great. May I request on 2:30, Lords, because it's long pending matter. And we are ready in the matter, Lord. I am not,
You argue today at 4:30. I can't have it at 2:30.
please, Lord.
Your
I
choice.
request on Monday itself, Lord, sir.
Not Monday, today or next Thursday. Or
Please,
next Friday.
Thursday. Right. Grateful.
Number 20, serial number 72.
List.
Page number 21, serial number 73 to 76.
Two 2014 matter. List.
Page number 22, serial number 77 to 79.
Paying for petition in this case.
List.
Preliminary hearing, serial number 1, Shri T.N. Vishwanath.
My lord, in this matter, I am appearing for respondent, my lordship. I seek 1 week's accommodation, my lord. I am a caveator, my lordship. Till last date, they had not cleared the objection, my lord. One short accommodation, my lord. I'll file objection, my lordship.
ಏನ್ ಬೇಕಾ? ಏನ್ ಮ್ಯಾಟ್ರ್ ಏನು? ನೀವು ಪರ್ಚೇಸರ?
I'm for the procedural, respond number 4.
ನೀವು ಗ್ಯಾರಂಟಿ ತಾನೆ? ಲಿಸ್ಟ್. ಇನ್ನು ಅವಸರ ಏನಿರಲ್ವಲ್ಲ?
6th. Serial number 2, Chokka Reddy.
6th.
Lord, I appear for the respondents, Lord.
Who are
A
you?
delay of 31 years,
No,
Lord.
appeared on the BC.
I appeared for one respond number 4.
You filed wakalat?
I'll file it
For whom? No, for whom are you filing wakalat?
for respond number 4.
He's the one who argued on.
Caveat.
For respond number 4, please. I'll just take instruction.
Serial number 2.
Lord, I deny him, Lord. Lord, you lost.
What is the executed?
Lord.
In execute ಮಾಡಿದ್ದಾರೆ?
Lord, I'm sorry, Lord, there's 31 years delay and 65 years delay from first sale.
You should not argue on merits when you talk about a settlement.
Settlement, Lord, on the last 2 occasions also, Lord, our clients have denied it. I have made this submission before this honorable court on the last occasion also. My learned friend wanted to, Lord, talk to the advocate as well as the client. Your lordships have told them, Lord, that if it is not done by this date, nothing is going to happen. But they have denied. Parties are present. There is no such, Lord, way out for settlement. Your legal years ಅಲ್ಲ ಇಲ್ಲ ಸ್ವಾಮಿ. ಇಲ್ಲ ಎಲ್ಲರೂ ಇದ್ದಾರೆ ನಮ್ಮ ಹತ್ರ ಎಲ್ಲ ಲೋನ್ ತಗೊಂಡು ಮಾಡ್ಕೊಂಡು ಈಗ ಲೋನ್ ತೀರ್ಸ್ಕೊಂಡಿದ್ದಾರೆ. Codal, they are not even the legal heirs. That was the issue before the AC court, not which has been accepted by the learned AC.
ಒಪ್ಕೊಳ್ತಿಲ್ವಲ್ಲ
ಇವಾಗ ಇಲ್ಲ ಸ್ವಾಮಿ, ಇಲ್ಲ ಸ್ವಾಮಿ,
ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಅವ್ರು ಡಿನೇಯಿಂಗ್ ಯುವರ್ ವೆರಿ.
ಇದಾರೆ ಇಲ್ಲ ಇದೆ, ನಾವೆಲ್ಲ ಪರ್ಚೇಸರ್ಸ್. ಇಲ್ಲ ಇಲ್ಲ, ನೋ, ಐ ಅಪಿಯರ್ ಫಾರ್ ದ ಸೈಟ್ ಓನರ್ಸ್. Lord,
ಅವ್ರು ಮೇಡಮ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಅಷ್ಟೊಂದು.
Lord, I also appear for site owners. They are also present before this honorable court. They are not willing to, Lord. ಯಾರಿಗೂ ಕೊಡೋದಿಲ್ಲ ಸ್ವಾಮಿ. There is an association formed, Lord. I'll that before the DC court I appeared. There is an association formed.
Finish.
ಸುಳ್ಳು.
ಏನ್ ಸೆಟಲ್ಮೆಂಟ್ ಆಗುತ್ತೆ? ಸೈಟ್ ಅಂತ ಕೊಡಲ್ಲ ನಿಮ್ಗೆ. ಮೇಡಮ್ ಇಲ್ಲ ಅಂದ್ರೆ ನಾನು ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
I'm sorry. ಇಲ್ಲ ಸ್ವಾಮಿ.
ಏನು when was the grant?
Blood grant apparently 1940, blood.
Is the petition?
Dates ನಾನು ಕೊಡ್ತೇನೆ.
That is 2010.
ಹೌದು.
So 30 years after the act.
Came into force.
Last chance. Next Thursday.
ಇಲ್ಲ bench change.
ಇವತ್ತೇ ನಿಮ್ಗೆ ಚಾನ್ಸ್ ಸಿಗ್ತಿರೋದು ಕಷ್ಟ.
Sixth. Number 3, Srinivasa BV.
ನೀವು ಯಾರಿಗೆ ಗ್ರಾಂಟಿಗ ಪರ್ಚೇಸ್ ಅಂತ? Right purchase. When was the grant? 79. Next year? ನೀವು ಕೊಡಲ್ವಾ? ಕೊಡಕ್ ರೆಡಿ ಇಲ್ವಾ? ಮತ್ತೆ ರಿಟ್ ಪಿಟಿಷನ್ ಯಾಕೆ ಹಾಕಿದ್ದಾರೆ? ಇಲ್ಲ, ಇವರ ಪಾರ್ಟಿ ಇನ್ ದಿಸ್ ರಿಟ್ ಪಿಟಿಷನ್? If you're not prepared to pay this amount, you will lose the property. Correct? See the second direction. The value of the site so determined shall be paid by the petitioners to the legal representatives of the grantees and obtain receipt acknowledgement and or confirmation of the same in accordance with law in order to validate their deeds of sale. So if you are prepared to pay that money to the LRs, you will get a valid title, or else you will lose. Appeal ಏನಕ್ಕೆ ಬೇಕು? You are not parties to that writ petition. ಇವಾಗ ಬಂದಿದ್ರ.
Let them go before the appropriate authority and consider as per.
The prayer of the petitioners is to direct the first respondent, Assistant Commissioner, consider their case in accordance with law for validating their say deeds as per the order rendered by this court, WP 23357/2011 on 17th of January 2023. It is the case of the petitioners that they are also similarly situated as the petitioners in WP 23357/2011, and the relief granted in that petition should also inure to their benefit. Is contended since the petitioners were not parties to the said writ petition, they would not be given the benefit that has been granted by this court in those writ petitions. In my view, since the petitioners claim that they are also similarly situated as those petitioners in WP 23357/2011, they are permitted to approach the first respondent, Assistant Commissioner, and establish that they are also similarly situated as the petitioners therein, and that they would be entitled for the benefits conferred to the purchasers of sites under that order. If the petitioners are able to establish that they are similarly situated, the Assistant Commissioner shall give them the benefit that is conferred on similar authorities as ordered in WP 23357/2011.
Number 4, PM Sidmallappa.
ಯಾವಾಗ ಡೇಟ್? ಯಾವ ಡಿಲಿನೇಷನ್? 51 ಅಲ್ಲಿ ಎಷ್ಟಿತ್ತು? 15 years. ಎಷ್ಟಿತ್ತು? ವಾಟ್ಸ್ ದ ಪೀರಿಯಡ್ ಆಫ್
Your Lordship, page number 66. I'll just, last paragraph, Your Lordship. ದರಖಾಸ್ತು ಡಿಮ್ಯಾಂಡ್ ಮಾಡಿ ವಹಿಯನ್ನು ಪರಿಶೀಲಿಸಿ ಲಾಗಿ ಸದರಿ ಪುಸ್ತಕದ ಪುಟ 65ರಲ್ಲಿನ ಕ್ರಮ ಸಂಖ್ಯೆ 30 ಪ್ರಕಾರ 1956-57ನೇ ಸಾಲಿನ ನಮೂದಿಸಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತೆ. ಆದ್ರೆ ದರಖಾಸ್ತು ಡಿಮ್ಯಾಂಡ್ ವಹಿಯನ್ನು ಕೂಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಿದಾಗ ಕ್ರಮ ಸಂಖ್ಯೆ 34 ಆದ ನಂತರ ಸ್ವಲ್ಪ ಸ್ಥಳಾವಕಾಶ ಬಿಟ್ಟು ಅಂದಿನ ಅಮಲ್ದಾರರು ಸಹಿ ಮಾಡಿರ್ತಾರೆ. ಆ ಸ್ಥಳಾವಕಾಶವನ್ನು ಉಪಯೋಗಿಸಿಕೊಂಡು ಕ್ರಮ ಸಂಖ್ಯೆ 35 ಎಂದು ನಮೂದಿಸಿ 21/5/52 ನಮೂದಿಸಿರ್ತಾರೆ. ಹಾಗೂ ಕ್ರಮ ಸಂಖ್ಯೆಯನ್ನು ತಿದ್ದಲು ಪ್ರಯತ್ನಿಸಿ ಕ್ರಮ ಸಂಖ್ಯೆ 38, 39 ಎಂದು 39-40 ಎಂದು ತಿದ್ದಿದ್ದು 35ರ ಮಧ್ಯೆ ಬರುವ 35, 36, 37 ಕ್ರಮ ಸಂಖ್ಯೆ ನಮೂದಿಸಿದ್ದು ಸದರಿ ನಮೂದು ಇರಬೇಕಾದ ಹಾಳೆಯ ಅಂಚುಗಳನ್ನು ಹರಿದು ಹಾಕಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಮತ್ತು ಈ ಪುಸ್ತಕದ ಮುಂದಿನ ಪುಟದ ಕ್ರಮ ಸಂಖ್ಯೆ 40 ಹರಿದು ಹಾಕಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಈ ಮೇಲ್ಕಂಡು that was the...
Then it's not a granted land. It's not a granted land. No, the grant register does not indicate it is granted. You have inserted the entry. And he has confirmed the insertion. And he has confirmed the insertion.
Rejected on the basis of I am not able to consider the appeal of the grant. I made the requisition for the Sana purpose and requisition was about and remand back to the deputy commissioner. Then again he has
You have a grant certificate. In the grant register, the allegation is that it has been tampered with. Therefore, even if you have a grant certificate, two authorities have seen the record. Why should I see the records? Madam,
ಅವ್ರ ಪ್ರಕಾರ ತಗೊಂಡ್ರೆ ಅದು ಇನಾಮ್ ಲ್ಯಾಂಡ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಅವ್ರ ಪ್ರಾಪರ್ಟಿ ವಾಸ್ ಅಲಾಟೆಡ್ ಟು ಇನ್ ಮೈ ನೇಮ್. They are not challenged anybody. The property was allotted and property was standing in my name. From past 1966 till the onward conditional age.
if the finding is that they have tampered with the register,
The view of the assistant
what is there to show that it is not tampered? He has seen the original register. Both the authorities have seen the original register.
That's why they are not taken the view that original of the land certificate have produced.
One minute. An application for resumption was made.
The record has to be copied.
ಏನಕ್ಕೆ two authorities?
They ಮಾಡಿದ್ದಾರೆ. The influence by the purchaser that was done by the
Application was filed seeking for resumption of lands. Thursday.
Number 5, Timmegowda.
ಯಾವ ಗ್ರಾಂಟ್? ಎಷ್ಟು ವರ್ಷ ಆದ್ಮೇಲೆ? No. When did you file the application for resumption? 30 years. From the act coming into force. And from the. No, then after. 30 years. 2009 ಅಂತ ಇಟ್ಕೊಳ್ಳಿ, 30 ವರ್ಷ. ಕ್ರಯಪತ್ರ 63ನೇ ವರ್ಷ. So after 50 years you want it to be. ಅವಾಗ ಸೇಲ್ ಪರ್ಮಿಷನ್ ಏನ್ ಪ್ರಶ್ನೆ ಇರ್ಲಿಲ್ವಲ್ಲ 63ರಲ್ಲಿ. If the first sale is valid, if the first, that is for the first sale, not for the second sale. If the first sale is valid, then second sale is automatically valid. Chetan. Yeah, bada badi. ಅಲ್ಲ ಅಟ್ಲೀಸ್ಟ್ ಒಂದು 20-30 ವರ್ಷ ಸರಿ, 50 ವರ್ಷ ಆದ್ಮೇಲೆ ಅವ್ರನ್ನ 63 ಇಸ್ವಿ ಕ್ರಯಪತ್ರ 63 ಇಸ್ವಿ ಫಸ್ಟ್ ಸೇಲ್ ಲೀಡ್. It's a long time, one generation. ಬೇಡ ಬೇಡ. Where is the order of the Assistant Commissioner? Assistant Commissioner?
ವರ್ಷ ವಿಳಂಬದ ಬಳಿಕ ಸಲ್ಲಿಸಿದ
An application for resumption was filed by the petitioner. You LR, sir? By the petitioner who claimed to be the LR of the grantee. The Assistant Commissioner rejected the said application on the ground that the land had been granted in the year 1947 and the first sale had taken place in 1963. And as on the date of the grant, the rule prescribed a period of non-alienation of 15 years. And since the land was alienated after 15 years, there was no violation of the terms of the grant. This order of the Assistant Commissioner has been confirmed with the Deputy Commissioner. The Deputy Commissioner, while dismissing the appeal, has also taken note of the fact that the application for exemption itself was filed nearly 30 years after the act having coming into force. And there was no justification for entertaining the appeal. Since principally, the Assistant Commissioner has recorded a finding that the alienation has been made in accordance with the terms of the grant and not within the prescribed period, there is no justification for entertaining this writ petition. Writ petition is therefore dismissed.
Number 6, Shri Nagaraja Iyer.
ನೀವು ಯಾರಿಗೆ ಗ್ಯಾರಂಟಿ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ where is the order? $13 years. Not after 13 years. That is the consideration on merits, annexure A.
Yes, Your Lord.
No, not after 13 years. First possession in Nagaraj Heggಡೆ 12 ವರ್ಷ. ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕದೆ 13 ವರ್ಷ ಆದ್ರೆ an application for exemption was filed. No, I know why you want notice to be issued, but I will resack. Application for exemption was filed with the Assistant Commissioner, and the same was dismissed. Where is the order? Or the Assistant Commissioner? Next, C na. D is the page number 4 ಅಲ್ಲಿ page number 4 ಮಿಸ್ ಆಗಿದೆ ಆರ್ಡರ್ ಅಲ್ಲಿ 3 ಆದ್ಮೇಲೆ 5 ಆಗಿದೆ.
Here it is meta mention.
The said application was rejected by an order dated 18/1/2010. Being aggrieved by the said order, an appeal was preferred to the Deputy Commissioner in the year 2010. This appeal was ultimately dismissed for non-prosecution on 22/6/2011. The petitioner has thereafter proceeded to make an application for recalling the said order dismissing the appeal for non-prosecution in the year 2024. That is after a period of 13 years. The Deputy Commissioner by the impugned order has come to the conclusion that there was absolutely no justification for entertaining an application filed for recalling 13 years after the order was passed. Deputy Commissioner has refused to accept the reasons put forth by the petitioner. In my view, the Deputy Commissioner was justified in refusing to recall the order dismissing the bill for non-prosecution because the application was filed 13 years after the dismissal. I find no reason to retain the petition is therefore dismissed.
Seal number 7.
$78 grand. Court ಬೇಕೇ ಬೇಕಲ್ಲ. Court permission ಏನ್ ಮಾಡಿದಾರೆ? ಏನ್ DC ಇಂದ ಹೆಂಗ್ ತಗೊಳ್ತಾರೆ? What provision? Limitation ಬರೋದೇ ಇಲ್ವಲ್ಲ, it's 4-2 ತಾನೆ. The land is granted after the act came into force. You have purchased it without 4-2. Then? 1990. 1990 is the first sale. 1990 alva na? Nodi, synopsis, 10/12/1990. And when the first sale took place, the period of non-alienation was still existing. I would have considered a case. ಎಲ್ಲಿದೆ 10 years ಅಂತ 78 ಅಲ್ಲಿ 15 ಅಲ್ವಾ 15 years madam. You have purchased within 10 years. You had purchased it beyond the 15 years, then I would have entertained your writ petition. In synopsis ಅಲ್ಲಿ 15 ವರ್ಷದಿಂದ ಬರ್ತಿದ್ದಾರೆ, that is the rule as on 1980. First sale is 1990.
Six. For order, seal number 8, Sri Prakasha K.
Order ilva. Petitioner is permitted to take out notice on the respondent through his counsel appearing in the trial court and inform him that the matter will be taken up for final disposal on the list on
13th December.
file an acknowledgement along with the counsel's name. Yes.
Seal number 9. Ravi.
ಅಲ್ಲ ಅವ್ರಿಗೆ same other permitted to take out notice. Inform them that the matter will be taken up next date.
13th.
Lawyer ತೊಗೊಳ್ಳಿ notice it.
Seal number 10, Sri Rudresha.
Same.
Seal number 11,
ಆಗಿದೆಯಾ? Same order. Take out notice on the council there.
seal number 12, Sri Nandish Gowda GB.
Take out notice on the council there. Respondent's counsel in the trial.
Seal number 13, Sri Sumant L Bharadwaj.
From where? What does your husband do? You are a tahsildar. The wife is before this court seeking for transfer of MC 13/2024. Which has been instructed by the husband before the senior civil judge and JMFC at Kustki, Koppala district. To the principal judge, family court at Bangalore. This court ordered notice to the respondent and also permitted the petitioner to serve a copy of the petition on the counsel appearing to the respondent in the trial court. Despite service of notice to the respondent husband, he has not taken steps to enter appearance. It is therefore obvious that he has no objection for the transfer. Since the wife contends that she is working, residing in Bangalore, residing in Bangalore, and has a 6-year-old child to take care of, be appropriate to transfer MC 13/2024 from the from the file of the senior civil judge and JMFC at Kustki, Koppala to the principal judge, family court at Bangalore. The family court, senior civil judge at Koppala, Kustki, Koppala is directed to inform the respondent husband that the matter is transferred to Bangalore and the matter would be listed before the family court Bangalore on
10th January. 10th January.
The Megade to enter appearance on 10th.
Seal number 14, Shri Narayan Swami HR.
Have you served a copy on the respondent? ಯಾವತ್ತು ಸರ್ ಮಾಡಿದ್ರೆ 26/10. ಅವ್ರ ಹೆಸರು ತೋರಿಸಿಲ್ಲ ಅಲ್ಲಿ, ಅದಕ್ಕೆ ನೀವು ಮೆಮೊ ಕೋರ್ಟ್ ಆಫೀಸಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಅವ್ರ ಹೆಸರು ತೋರ್ತಾರೆ ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ. ಸರಿ, ಬಟ್ ಅವ್ರು ಬಂದು ಏನಾದ್ರು ನಮ್ಗೆ ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಬಂದಿದ್ದು ಗೊತ್ತಾಗ್ಲಿಲ್ಲ. ಯಾವತ್ತು ಆರ್ಡರ್ ಮಾಡಿದ್ದೆ? On 22/10/2024, this court permitted the petitioner to take out notice on the counsel who represented the respondent in the trial court. Today, a memo is filed stating that the copy of the petition was served on the respondent's counsel. And it is seen that the signature of the counsel who represented the respondent, Shri Lokesh Alva, has received the petition copy. Despite service of notice on 26th of October, there has been no appearance on behalf of the respondent. It is therefore obvious that the respondent has no objection for the transfer. So the wife has filed this petition seeking for transfer of MC 277/2023 from the court of the senior civil judge Mandya to the family court at Kolar, contending that she has been employed at Kolar and therefore it will not be possible for her to travel to Mandya. So in my view, the petitioner has made out a case for transfer and accordingly MC 277/2023 pending before the senior civil judge Mandya is transferred to the principal family court at Kolar. The senior civil judge at Mandya is directed to inform the respondent or his counsel that the petition has been transferred to Kolar and the matter would be listed before the court at Kolar on
January. 10th January. Seal number 15, P. Nataraj.
Speed post ಮಾಡಿದ್ದಾರೆ. ಯಾವತ್ತು ಮಾಡಿದ್ರು? 25th of memo is filed stating that the copy of the petition has been served on Shri T. N. Gopal Gowda, the counsel who represents the respondent in the trial court. Office to print his name in the cause list and relist on 6th.
Number 16, Yes, Nagraj.
ಏನಂತ?
And RTC was taxed in before the 2002 at least Udara. You there is a from Asif Dawla. There are different persons. The guide is simply by Jara first the respondent will not the party report to respondent. Udara in Asif Dawla.
ಕರೆಕ್ಟ್ ಇದೆ ಆಸಿಫುದ್ದಿಲ್ಲ
Please Udara. Dawla. Dawla. Asif Dawla. Asif Dawla is different from Asif Udara.
The RTC was mutated from the name of
From
Hafiz Uddal
Hafiz Udara
to
ಜೈರು
it is his mother. So the Kata was standing in the name of this Hafiz
ಆಸಿಫುದ್ದಿಲ್ಲ
It was not standing in the name of the government.
Now it is the tax in the name of government.
That order has been set aside by the deputy commissioner, by the deputy commissioner.
Deputy commissioner is not set aside. It is applied the orders of the assistant
Sorry.
commissioner.
This court set aside that order.
So, Honorable Court, without, I have not been made as a party, I am.
You have no interest in the matter. It's only between the government and that person. You did not challenge the order by which the entry was made in favor of the government.
Because.
You accepted that.
No, say.
You will have no interest if the property belongs to the government. You are yet to get a right on the land.
Great question, madam, because now I am producing, I am the person of the entire of the property, and I have produced the photographs, I raised the coconut tree, and from all.
If you have a decree,
That's question is.
if you have a problem about possession, you claim that you have a decree for injunction or the suit filed by him is dismissed. So therefore,
It is dismissed against me for the granting of permanent detention, and appeal is also filed. That is also confirmed. My position is confirmed by both.
how will this order affect your possession? This order is only,
This order will not affect the position. Has already been, Supreme Court is decided.
I will not say all that. I will only say that this writ petition is confined only to the entries made and will not relate to the possession of either of the parties.
It is always not understood.
I will say that. that is all.
ತಾವು ಈಗ not the possession ಈಗ both of them are claiming in possession. Not
No, he
first
claims,
of all, alla,
he claims
one-
your suit for injunction is dismissed, confirmed in appeal.
correct my lord, that is
Therefore-
because I have not claimed the declaratory suit. That's why on that ground it
Because
is.
for whatever reason you accepted that
Yes,
order.
sir. Alla,
Accepted that order, therefore you are bound by the order.
That's correct, my lord. Now what my friend has come before this court, my lord, saying that he is not a party. Your lordship has says, my lord, he was
Martin, I
not
will clarify
interested
that.
at all.
I'll clarify that.
Allah.
This review.
Clarify better. This order will not affect any either of the possession of either of the parties. Anta. That has to be decided independently by court.
This review petition is filed seeking for review of the order passed by this court in WP 22835/2015. This court allowed the writ petition after noticing that the Kata of land wings number 15/7 and 15/8 stood in the name of Asifudullah, and on his death, at the request of his wife Zabirunisa, the entries were changed
In the name of wife.
number 31/2002 and 2003. This court concluded that the order of mutation was essentially an inheritance proceedings in which it had been held that the wife of Asifudullah had succeeded to the property and consequently her name was to be entered in the revenue records. Next part. This court took note of the fact that this order of mutation in favor of Zabirunisa was challenged by the petitioner herein. Nivedana, the petitioners herein. And in an appeal filed by them, the Assistant Commissioner had set aside the order of mediation in favor of Zabirunisa and had ordered that the lands be registered in the name of the government. Next. This order directing the registration of the name of the government in the revenue records was accepted by the petitioners herein who had preferred an appeal before the Assistant Commissioner. Next. However, the son of Asifudullah, that is Zubir Ahmad, preferred a revision to the Deputy Commissioner. And the Deputy Commissioner, after taking note of the fact that the revenue entries did stand in the name of his father, however, came to the conclusion that the order of the Assistant Commissioner was proper and dismissed the revision. This court accordingly set aside the order on the ground that if the revenue entry stood in the name of Zubir Ahmad's father and thereafter his mother, the authorities in excess of the pass under 136 could not have directed the name of the government to be registered. Next para. The petitioners have now filed this review contending that
Review
they are
petitioner.
in possession of the property and the order passed by this court in relation to the revenue entries are affecting their possession. They seek to contend that Zubir Ahmad had instituted suit for injunction, which has been dismissed and confirmed in appeal. And on the strength of the order passed by this court, attempts are being made to dispossess the petitioner. Next paragraph. It is to be noticed here that this court was only dealing with entries in the revenue records. This court, after noticing that the entry was standing in the name of Zubir Ahmad's father, came to the conclusion that on his death, the entries were required to be transferred in the name of his wife and thereafter to the name of his son. And the authorities could not, in excess of the pass under section 136, direct the name of the government to be entered. In my view, in such a review petition, in which, in my view, in the light of this particular fact, and keeping in mind that the petitioners here did not challenge the order of the Assistant Commissioner, which directed the registration of the name of the government in the revenue records, cannot file a review petition. I find no grounds to entertain the review. The review is dismissed. However, it is clarified that the order passed by this court will not in any way determine the position of either of the parties over the lands in question.
Yes. Not less. ಹೇಳಿದ್ರಲ್ಲ.
Already said that it was been dismissed and confirmed in the
Dismiss ಆಯ್ತಲ್ಲ.
ನಾನು ಅದೆಲ್ಲ ಏನು ಹೇಳಕ್ ಹೋಗಲ್ಲ. ಅವರ
Even now, Lord, he cannot seek any order.
in the light of the disposal of the review petition on merits, there will be no need to consider the application for delay.
Seal number 17, Shri T.A. Karumbaya.
ಯಾಕೋ ಮೈನವ್ರು ಇಷ್ಟು on 19/11/2024, this court permitted the petitioner to correct the cost rate and also directed the petitioner to deposit a sum of rupees 2 lakhs in a period of 2 weeks and proceeded to grant an interim order. Learned counsel for the petitioner has filed a memo stating that the cost rate as printed is incorrect and he wishes to correct the same in terms of the memo. He submits that he has also purchased demand draft but could not deposit the amount in view of the discrepancies in the cost table. So the memo filed by the petitioner is accepted and is permitted to file an appropriate cost table. So he is also permitted to deposit the demand draft within a period of 1 week. ನೀವು ನಿಮ್ಮಿಂದ ಡಿಲೇ ಆಯ್ತು. Third.
Seal number 18, Shri T.N. Vishwanatha.
Who's R6? R6 here.
Respondent number 5, 7 and 8.
6 ತಗೊಳ್ಳಲ್ವಾ ನೀವು?
ಇಲ್ಲ 6 ಗೆ
Week's time is granted to the.
Seal number 19, Shri Venkateshwar Manakar.
ಏನು? ಹಾಕಿದೆ. ಕೊಟ್ಟಿದ್ದಾರೆ. It is noticed that the amended petition has been filed on 22/11/2024 before the court. Hence, office objections stand complete with. The list. 6th.
Seal number 20.
I beg to appear for petitioner, my lord. I am a purchaser and wants to compromise with the grantee relating to 2 acres of land. Swami,
ಹೋದ್ಸಲ ಆಗಲ್ಲ ಅಂತ ಹೇಳಿದೆ ತಾನೆ.
ಅದೇ ಅದಕ್ಕೋಸ್ಕರ ಒಂದ್ ಸ್ವಲ್ಪ ಟೈಮ್ ಕೊಡಿ. ಅವ್ರೇನೋ ರಿಜಿಸ್ಟ್ರೇಷನ್ಗೆ ರೆಡಿ ಮಾಡ್ತಾ ಇದಾರಂತೆ.
List. 6th.
Seal number 21, Shri Chokka Reddy.
Who's R8? Who's R8?
For 7 and 8, I wanted to take to file wakalat, my lord.
Also undertakes to enter appearance for R8. Ready na?
ಅಲ್ಲ, next week ಹಾಕಿ.
ಫಸ್ಟ್ ಬರ್ಲಿ ಅವ್ರು. ಅವ್ರು ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಒಂದು
7 and 8.
ಈ ಲಿಸ್ಟ್ ಆಯ್ತು, ಅವ್ರು ಬರ್ಲಿ, ರೆಡಿ ಆಗ್ಲಿರಿ. ಅವ್ರು ಇನ್ನೂ ಫೀಸು ಬಂದಿರಲ್ಲ, ನೀವು ಆಗ್ಲೇ 12th.
Seal number 22.
In office objections. ಇನ್ನು ಟ್ಯಾಲಿ ಆಗಿರೋದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನೋಡಿ. ಏನೋ ಪಾರ್ಟೀಸ್ ಡು ನಾಟ್ ಟ್ಯಾಲಿ ವಿತ್ annexure F. ಇಲ್ಲ, ಅದ್ರ ಮೇಲೆ ಪಾರ್ಟೀಸ್ ಡು ನಾಟ್ ಟ್ಯಾಲಿ ವಿತ್ annexure F ಅಂತ ಬರ್ದು ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ. ವೀಕ್ಸ್ ಟೈಮ್ ಇಸ್. ನೀವ್ ಯಾರಿಗೆ? ನೀವ್ ಯಾರಿಗೆ? ಅವ್ರು ಇವಾಗ ಹೆಂಗ್ ಯು ಆರ್ ಸೆಲ್ಲಿಂಗ್ ದ ಪ್ರಾಪರ್ಟಿ?
Same, my lord, yesterday's matter. 14 years, 7 months, 5 days delay, my lord, in applying for restoration and recalling. My lord, appeal was dismissed as withdrawn, my lord, on 17/7/2007. In February 2022, the application was filed for recalling. The deputy commissioner has dismissed, saying that there are no bona fides. Allegations is made against the advocate. No complaint against the advocate. Then, my lord, record of rights are changed in the year 2007-2008 in the name of grantee. The facts of the case show, my lord, there is a total, my lord, negligence on the part of the appellant. Deliberately, they have not taken any steps. The order of the DC.
Party had signed the memo, adena?
Please, my lord, same.
There are 2 cases. 4. When is the other case was posted? The other 2 cases.
Yesterday it was.
512. ಇದೇ ತರ ಕೇಸ್ 5ನೇ ತಾರೀಕು ಹಾಕೊಂಡಿದ್ದೀನಿ. ಆ ಕೇಸಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ಟಿಲ್ಲ ನಾನು. ಆ ಕೇಸಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ಟಿಲ್ಲ ನಾನು. ಈ ಕೇಸಲ್ಲಿ ಕೊಡಕ್ಕಾಗಲ್ಲ.
Generally, the AC and NBC have signed both the parties. The advocate works with the he works with the and the RC gets that start with page number current file number. Page number advocates the participated. Memo has filed notice issue 97/2007.
Memo an appeal is filed by the purchaser. Memo is filed by the council containing the signature of the party. Withdrawing the appeal. Why should the
ಸ್ಟೇ ಕೇಳ್ಬೇಕಲ್ಲ ಸರ್ ಅವರು? ಡಿಸ್ಪೊಸಿಷನ್ ಆಗುತ್ತಲ್ಲ, 14 ವರ್ಷ ಹೆಂಗ್ ಸುಮ್ನೆ ಇರ್ತಾರೆ? ಮತ್ತೆ
fifth consider ಮಾಡ್ತೀನಿ. Fifth.
Remaining 3 matters all post along with.
ಅದೊಂದು ಬೇರೆ
Total 4 matter arising out of the common.
Number 23.
ಏನೋ ಸೆಟಲ್ ಮಾಡಿಸಿ ಶಾಸ್ತ್ರಿಗಳೇ.
ಸರಿ,
ಅವ್ರ ಬರೀ
ಸೆಟ್ಲ್ ಆಗಿ
ಸೆಕೆಂಡ್ ರೌಂಡ್ ಆಫ್ ಸೆಟಲ್ಮೆಂಟ್.
ಇವಾಗ
ಸೆಕೆಂಡ್ ರೌಂಡ್ ಆಫ್ ಸೆಟಲ್ಮೆಂಟ್ ಅದೇ
14 ವರ್ಷ
ಮಾಡಿಸಿ ಪಾಪ ಪಾರ್ಟಿಗೆ ಸೆಟಲ್ ಅಂತ ಸೆಟಲ್ ಮಾಡಿಸಿ.
Number 23. CM Shivaprakash.
My lord, I undertake to appear for respondent.
ಮೆಮೋ ಫೈಲ್ ಮಾಡಿ.
But there is impropriety in the service. They have not obtained the summons from the office and they have just served a copy, Xerox copy through the advocate who was appearing in the trial court. I am ready to file power for them. I pray 2 weeks
takes
time.
to enter appearance on behalf of. ಎಷ್ಟೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ನೀವು? Relist on. ಕೊಡ್ತೀನಿ. ಅವ್ರು 2 weeks ಬೇಕು ಅಂದ್ರು. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ತೀನಿ ಸರ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ 6.
Okay, I'm ready.
Number 24. Shri Kumar JC.
ನೆಕ್ಸ್ಟ್ ಏನಲ್ಲಿ ಕಾಮನ್ ಆರ್ಡರ್ 8 ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ಇದು ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್ ಪೇಜ್ ನಂಬರ್ 38 ಮೇಲೆ ಫ್ರೆಂಡ್ಲಿ ಇದೆ.
ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ annexure B to be
ಫರ್ನಿಶ್ ಮಾಡಿದ್ದೀವಿ ಮಾಡಿ.
ಇನ್ನೇನಕ್ಕೆ ಬಂತು?
ಇನ್ನೊಂದು ಪಾರ್ಟೀಸ್ ನಾಟ್ ಟ್ಯಾಲಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಪೇಜ್ ನಂಬರ್ 38 ಸಮಯ ಇದು 8 ಕೇಸ್ನ ಒಂದೇ ಕಾಮನ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ಪೇಜ್ ನಂಬರ್ 38 ಇವರು. This is in the
section deferred for the present. In matter ಏನು?
ಇದು ಪರ್ಚೇಸರ್ ರಿಟ್ಪಿಟಿಷನ್ ಇದು.
ಯಾವ ಗ್ರಾಂಟ್?
ಗ್ರಾಂಟ್ ಇನ್ ದಿ ಇಯರ್ 1988 ಇವರು.
After the act came into force.
Please.
ಮಾರಾಟ ಆಗಿದ್ದು
2005.
How many years?
Within 6 years they have filed the petition. Matter may be compromise manner kindly issue notice to the R5.
HCB accepts notice for R1 to R1 to R4. Issue notice to R5. It's an interim stay of presumption of the impugn order instead of you.
Much.
Number 25. KL Srinivas.
Commissioners, my lords. My lords, the office objection is, my lords, I have paid the court fee of ₹100, my lords. Deficit court fee. Court fee has been paid because the order of challenge is the order of the assistant commissioner and deputy commissioner.
He to annexure not made a party.
Please, my lords, because after the disposal of the petition before the AC, my lords, he died, and in the before filing of the
Who died?
appeal, he is R2 before the AC, my lords. Ramaya, son of Manjaya. At annexure E.
He is the purchaser.
Illa, he is the son of the grantee. I am the purchaser.
No, before the assistant commissioner,
Before the second respondent, my lords.
Nagesh, they were the grantees.
Yes, they are.
Rama and Ramaya are the respondents.
My lords, KC Chandrama is the purchaser. this Ramaya is son of the grantee. So they have arrayed him as a respondent in the, before the AC.
ರಾಮಾಯಣ್ ಮಕ್ಕಳು ಹಾಕಿದ appeal.
ಹೌದು. This Nagesha Lakshmi.
Is no more alive.
No.
Is reported that R2 before the assistant commissioner, that is Ramaya, is not alive. Is also stated that his children were the applicants seeking for exemption. And therefore, Ramaya is not made a party. This submission is accepted. Case,
ಆಮೇಲೆ ಇದು the land was granted on 7/4/1960, my lords.
yes.
And the land was sold in favor of the petitioner on 20th March 1992. And thereafter, the petition came to be filed after 22 years on 4/9/2014, my lords.
CGP accepts notice for R1 to R3, issue notice to R4 to R11, interim stay.
And I may be permitted to serve the copy on the council opinion before the.
Petition also permit, ಅವ್ರು ತಗೊಳ್ತಾರಾ?
I will try, my lords.
In addition, petitioner is also permitted to take out notice on respondent so and so.
4 to 11.
Council before the deputy commissioner.
Stay may be granted.
Number 26, Shri Devi.
Lord, I am appealing to the petitioner. My lord, the office objection is that we have not served a copy on the caveator. Caveator is a stranger to the bank. He is not a party before any.
Serve a copy since he has filed the caveat, why can't you serve a copy?
My lord, he is not a party. He is not a party to the proceedings.
Where's the caveat petition?
Lord, even in the cause title, it has been mentioned he is not a party to the petition, proceedings.
He says he had challenged the order in PTCL 35/0708.
My lord, I'm not aware, my lord, that he is challenged. One Ajay Kumar is the caveator. He is not a party to the
No, he
proceedings.
says he has challenged PTCL 35/0708.
46 is the appeal, my lord. 35, I don't know in what capacity he has challenged it, my lord. Even before
I
the,
think he is the son of the first respondent, Chikkapaya. Chikkapaya was the second respondent with the deputy commissioner. I think he is his son, Shiv Kumar.
I'm not aware, my lord. Chikkapaya is alive.
Live.
He is alive. Lord, he could not have challenged 35 because if he is a son of the Chikkapaya, it is the order is in favor of the Chikkapaya only, my lord.
ಯಾರು ಲಾಯರ್ ಹಾಕಿರೋದು? Is noticed that Shiv Kumar, who had entered caveat, was not a party before the assistant commissioner or the deputy commissioner. It's also noticed that his father Chikkapaya was read as the first respondent with the deputy commissioner. Senate Council for the petition submits that Chikkapaya is alive and hence the question of Shiv Kumar entering caveat would not arise. So in view of the above, office objections are overruled.
My lord, the challenge is after 42 years, my lord. The first sale was in 1966. And then the grant was in 1953, my lord.
53.
53.
CGP accepts notice for respondents 1, 2, 3. Issue notice to R4 to R9.
Lord, I have sought for a stay of these. Lord, stay of annex E, my lord.
Whatever.
Till number 27, Harish Bandari.
Obliged.
Objections, your lordship. Index is for date, it's minor, can be carried out, your lordship. Of course, this is a case, your lordship. Grant is of 51/52, your lordship. Now the
You are granting a purchaser.
purchaser, your lordship. Grant is of 51/52. Now, your lordship is after 84, one sale was taken place. I
84.
purchased in 2022,
84.
22.
First sale ಯಾವಾಗ?
First sale 84. Grant in 51, 52. First sale 84. Then 2022 I purchased. Now the grandson files the petition.
Notice for respondents 1 to 4, issue notice to our interim stay. Office objection we complete with immediately. Complete right now.
Please, Your Lordship.
28. Sharat Gowda.
Purchaser's petition matters. Lord, the office objection is in the impugned orders, there are certain respondents, my lords, why they have not been made as parties. They are all our vendors, my lords. Respondents 2 to 7,
The submission of the concept that R2 to R8.
R2 to R7 are our vendors, my lords. R8 was one of the applicant which challenged the sale deed seeking for restoration. Assistant Commissioner dismissed the application, but he has not chosen to file appeal before the Deputy Commissioner.
It is stated that R2 to R7 are the vendors of the petitioner and they have no subsisting interest. And hence they are not made parties. It's also stated that R8 was one of the applicants who had sought for resumption. But on the application resumption being dismissed, he did not challenge it and hence is not made a party. But on Madad Vasi,
I'll make it, my lords. R8 and Madbid.
or in my view, it would be appropriate to direct the implement of R8 in annexure A as respondent number 423 as a number 4.
1995 is the first sale, my lords.
Grant
Grant 1978 is the grant.
photo permission illa.
Lords.
Photo permission illa.
Photo permission in Illila, 1978 grant. First sale is 1995. Challenge is laid in 2012, 13.
8 years.
My lords, 1995 to 2014, 17 years, after 17 years. 1996, after 17 years, challenge is laid. And the Assistant Commissioner, my lords, apart from this aspect, also deals with other aspects at page 238, if your lordship sees.
CGP accepts notice for R1 and R2, issue notice to R3 and R4. Issue interim stay.
For hearing on I.
Right, sir.
29. Vishwanath Shetty.
R4, my lords, I'll just now itself.
I pay for petition. Well, now respond number 3. LRs have filed this application. Order 1, Rule 10, Class 2, whatever it may be, they are the LRs of this is the R3 Pujappa. I have no objection.
They are granting. So please.
No, I am the purchaser. They are grantees.
Pujappa is the grantee.
R5 to R8 grantees LRs tane. Please, my lord.
They filed application now to come on.
R5 to R8 are stated with the LRs of the grantee. The application pleading is required to be allowed, it is accordingly allowed. First rate will be amended. Ready, nine?
Matter may be taken up next week, my lord. I will
Non-ready.
discuss.
List. 6th. Interim order.
Well, interim order is there, kindly be extended.
Number 30.
My lords were to recall, my lords was disposing of this matter on the previous occasion when I pointed out that this is a grant relating to unauthorized occupation. My lord's judgment itself, my lords had referred to.
My parties are not cooperating, my lordship. They are not come to office at all, even though after intimation. My lordship, 66 grant to 69 sale agide.
ಇಲ್ಲ unauthorized occupation ಆದರೆ ಬರಲ್ವಲ್ಲ.
Record shows that, my lordship. They have produced some record.
Page 75, my lords may come directly to my lord.
But that is not taken plea before the any court.
An application for resumption was filed which was accepted and the order was, and the land was directly resumed.
1966.
This order has been confirmed in appeal. As a consequence, the purchaser is before this court by way of this writ petition. And Constable, the petitioner points out that even according to the impugned orders, the land in question was regularized in favor of the grantee because he was in unauthorized possession. And the land was not granted because he belonged to a scheduled caste or scheduled tribe.
Even as on that day, he was not, my lord.
Since only those lands which are granted to persons belonging to scheduled caste, scheduled tribe, because they belong to that particular category, it only come within the purview of the PTCL Act. The impugned proceedings are one without jurisdiction. This court in WP number so and so has already held that if the unauthorized occupation of a person over a land is regularized by the government, merely because that person belongs to scheduled caste, it can't be considered as a granted land. Because the land had not been regularized because he belonged to the scheduled caste. The right of the state judgment, the impugned proceedings cannot be sustained and they are accordingly set aside. The application of presumption is therefore.
In this case, scheduled tribe.
Naika. Sir.
ನಾನು ಮಾಡಿದ್ದೀನಿ ಇನ್ನೇನು confusion. Last week. Where's the order that I passed? You have a copy of the.
My lord, I have a coordinate bench order. Pass that, my lord. It refers to Bhairappa itself. And the coordinate bench is orders here with me. I'll just pass that on.
No, I had passed an order.
My lodge is also there, but that's on delay and latches. I have that. I'll get pass on the number as well, my lord. It refers to Bhairappa itself. It goes back to Bhairappa itself, my lord. Good.
Cinema 31.
Please, oblige.
Sarvana, yes.
Respond
Who's
number
R4?
4, notice ಹೋಗ್ಬೇಕಾಗುತ್ತೆ 19/4/2020 respond number 4 died minutes.
Who's R4?
He's the one of the purchaser minutes.
ನೀವ್ ಯಾರಿಗೆ?
I am the grantee for the petition.
She noticed to IA 1, 2 and 3 of 24.
Cinema 32. Yeah, Krishnamurthy.
For the petitioner, my lords. Really mistakenly, my lords, I have mentioned respondent number 7. That's on the last occasion, my lords, my impleading application was allowed. And in fact, I had mentioned in the application proposed respondent number 7 that came to be allowed. Is respondent number 8, my lords. 7 is already on record. I have made a mistake. I'll file a necessary applications, my lords.
It is stated that in the last occasion, it was stated that respond number 7 had refused notice, though it was respond number 8. So in view of the above, notice to R8 was refused service is held sufficient. Cost to be amended.
I'll amend the cost.
Number 33, the Sailesh Kumar.
Yes, a for petition.
Lord, I pay
For
for
the
the
applicants,
Lord, I pay for the respondent number 3 and 4. My lord, on the last occasion, my lord, your lordship may kindly see the order dated 22/11/24, my lord. The Ashwin Kumar, who had filed the application, my lord, to implead, was permitted, my lord, to retire from the case. My lord, they are also, my lord, purchasers of the property, LRs of the purchasers. I am also appearing for some of the LRs, my lord, R3 and R4.
is anybody appearing on behalf of the?
No one is appearing. My lord, if I may submit, my lord, this land was granted in 1940.
Like IML ಏನ್ ಮಾಡ್ಬೇಕು?
That might not be necessary for this reason, my lord, because their only stand was that permission was not taken. Now, my lord, we have received.
You ready?
No, lead, my
My
lord.
lord,
I need 1 week's time. 1 week.
Permission.
I'm not prepared.
I'll
Fix the date for this.
Relist.
My lord, I'll date my. Yeah. My lord.
Number 34.
My lord, I'll file this memo, my lord, says that, my lord, permission was obtained by us, while, I'll.
Number 34, Shajit Kanya.
Lords, I appeal for the petition of this matter, my lords. This matter was dismissed for non-prosecution, my lords. Partially it was complied. We wanted a few documents and some typed copies, my lord. I filed the restoration IA in 20.
First comply with the office objections first.
My lords, it has been dismissed, my lords, so it
I'll
may
permit
kindly.
you to comply. You comply first.
Yes, my lords, it may kindly be
Notwithstanding
restored.
the order of dismissal for non-prosecution on 30th of May 2023, petitioner is permitted to comply with the office objections. Relist. Comply with the office objection, then I'll record.
6, 6,
Much obliged.
Fine.
Number 35.
I pay for the petition from yesterday's use. My lord, lordship, kindly take my annexure M1, my lord.
ಏನ್ ಮೇಡಮ್?
Taken up on Monday.
ಅಲ್ಲ ಅವರು ಸೇಲ್
I mean-
ಮಾಡ್ತಾರೆ.
I mean,
Madam,
just
direction
copy.
is against fourth respondent. But
Yeah,
we do have this RTC.
I'm producing this RTC. They have filed it in Tapal and that was not brought to the knowledge of the AC and DC alone.
Right, what does he propose to do now that there's an interim order? What does he propose to do? As on the date of this order, so it's already a stay.
AC lordship.
Man, very
That
next day it was informed.
ಅವರು ಟಪಾಲ್ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ that
ಆಯ್ತು,
that
what
was
is,
not brought to the now changed your lordship.
is restored in his name?
Yes, your lordship.
ಆಗಿದ್ಯಾ?
ಆಗಿದೆ. That is what I am producing. They even mentioned that repetition number also.
Madam, now the respondent number 4 yesterday.
ಗಲಾಟೆ ಮಾಡ್ಬಿಟ್ರಿ ನೀವು, ನಿಮ್ ಪರ ಯಾರು ಇದ್ರು ಅವ್ರು.
Please, record ಮಾಡ್ಬಿಡಿ.
What is the application for direction now?
Direction man IA1 not to create any encumbrance by the fourth respondent. Fourth respondent has been served. NNO absent. Now IA number 2 is against the government. Restore the entries.
A number 2 now. IA 2/24. This was direction be issued to the government to restore the revenue entries in favor of the petitioner in view of the interim order granted by this court. When HCP places on record the RTC, which indicates that the revenue entries have in fact been restored in favor of the petitioner in view of the above, IA 2/24 would be unnecessary.
But IA number 1.
Stay idea, alle?
Stay there.
Both the parties are direct to maintain status quo as it exists today.
Please.
For further consideration, number 36.
Press time in this matter. Locus stand ಇದೆ ಮನೋಜ್ ಇರಲ್ಲ. Press time next week any date ಮನೋಜ್.
List.
6. Number 37, Shri Nishant Devi. Number 37.
ಮಾಡ್ತೀರಾ?
37. For admission, number 38 adjourned, number 39.
But this may be allowed, only this thing is. They sought for transfer of GNWC. I did try for a settlement, doesn't look like it.
Last
This can be
occasion,
transferred.
Lordship has directed the respondent to speak with the parents of the petitioner. He is not interested. So simply is.
That is not so. He's definitely interested, but there are other things.
The wife is before this court seeking for transfer of GNWC 64/2023 from the 6th additional senior civil judge Bangalore Rural to the senior civil judge at Hoskote. What is the other CP?
Milord.
7th additional senior civil judge.
7th additional. This code, Lakshman. CP 297. CP 297 connected matter. 38.1. Yeah, there. The wife contends that she is residing with her parents at Hoskote, and she has also instituted a proceeding for dissolution of the marriage in MC 23/22. It will therefore be difficult for her to travel to Bangalore. In my view, this request is genuine and deserves acceptance. Consequently, GNWC 64/23, pending on the file of the 7th additional senior civil judge Bangalore Rural District is withdrawn and transferred to the court of the senior civil judge at Oscote. Since the parties are represented, they shall
My
appear.
lords, one prayer. Can all the petitions be called on the same day, clubbed together? Because he's in the government department. He doesn't have to go 3 times in a month.
What is
That
the
is,
other case that is?
my lords, there is restitution and divorce. MC 3438 of 21, which is already there. And MC 257 of 22, my lords.
What did I transfer? Now?
Already transferred.
Already transferred, yes.
The third council appearing for the party submit that the petition filed for 3438 is not transferred.
It's transferred, my lord. It's transferred. 3438 is the restitution petition filed by him earlier for 21.
This is only for GNWC.
Yes, GNW.
Yes, I just wanted,
The third council of the parties submit that there should be issued to the senior civil judge Oscote to ensure that all the 3 proceedings between the parties be posted on the same day. That is MC 3438/2021.
and
MC 64/23 and MC 23/2022.
MC 257 of 20.
Senior civil judge Oscote is directed to ensure that all the 3 proceedings between the parties are posted on the same day.
Grateful, my lords.
Number 40.
Appearing for respond number 5, my lord.
Appearing for respond number 1.
Petitioner kindly pass out.
In password and
CP
Senior is under plan Samar.
Kindly have it in the next
Elinda
week.
elige?
Sir, they're seeking for a transfer of OS to Nelmangla to Bengaluru, my lord. The parties are staying in Nelmangla, my lord. They could have proceed there only, man. Bengaluru and then Alinda and it will not take much time to come. Our PNDC but they are seeking for a transfer, my lord. Even PNDC is also now they are contesting, my lord, that PNDC will transfer into OS, my lord.
No, OS 2013 ಇವಾಗ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಕ್ಕೆ ಹೇಳ್ತಿದಾರ.
ಅದಕ್ಕೆ ಅದೇ
OS ಇರುವುದು ನೆಲಮಂಗಲದಲ್ಲಿ.
ಆಯ್ತು 11 ವರ್ಷ ಆದ್ಮೇಲೆ ಟ್ರಾನ್ಸ್ಫರ್ ಕೇಳ್ತಿದ್ದಾರೆ.
ಅಲ್ಲ ಈಗ PNDC ಇಲ್ಲ ಹಾಕವ್ರೆ.
ಹಂಗಾರೆ ನಾಳೆ ಇನ್ನೊಂದು ಕಡೆ ಹಾಕಿದ್ರೆ ಅಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಕ್ಕಾಗತ್ತೆ.
ಅಲ್ಲ kindly pass out my senior.
It is some short distance, my lord. Their parties are staying in Nelmangla only, my lord. Much of it.
Number 41.
For the petitioner, my lord.
As for the petition will be allowed, my lord, but the only prayer is that, my lord, in a time bound manner, the MC petition may be disposed, my lord.
ಹೆಂಗಿದೆ ಕೇಸ್ ನಮ್ಗೆ ಏನ್ ಗೊತ್ತಿರೋದ್ರೆ?
ಯಾಕಂದ್ರೆ, my lord, 2021 initially it was been filed before the senior civil judge, Bangalore Rural District, my lord. Later it was been transferred to Oscote.
Seeking for transfer of MC 33/2023, which has been instituted by the husband before the senior civil judge James Oscote, Bangalore Rural District, to the principal judge family court at Tumkur. Non-counsel appearing for the respondent submits that he has no objection for the said transfer. So in view of the above, MC 33/23 pending on the file of the senior civil judge and James Oscote is withdrawn and transferred to the principal judge family court Tumkur. The parties are directed to be present before the court at Tumkur on 10th January. The principal judge family court shall endeavor to expedite the disposal of the proceeding subject to the cooperation of both the parties.
Number 42 adjourned. Number 43, Kiralian.
Lords, appearing for respondent, proxy counsel representing Rakesh Kini, counsel on record notes. Lords, my instructions are, my lords, let it be allowed, my lords, without recording, there's no objections from my side.
The wife is before this court seeking for transfer of MC 90/24, which is pending before the principal judge family court, Udupi, which has been issued by the husband to the principal judge family court, Mangalore. The wife contends that she is residing at Udupi and it will be difficult for her to travel to Mangalore to defend herself. Maklidara? It is also stated that the petitioner has a 10-year-old son to look after and cannot go to Mangalore to defend herself. So, in my view, this submission of the counts of the wife merits acceptance and is accordingly accepted. Consequently, MC 90/24 pending on the file of the principal judge family court Udupi is withdrawn and transferred to the principal judge family court Mangalore. Since both the parties are represented by counsel, they shall appear before the family court on
10 January. Number 44, Venkatesh R. Bhagat.
wife's petition seeking transfer of the petition filed in Karwar to the Bangalore, my lord. She filed a MC petition here for divorce.
Counsel is permitted to take out notice on the respondent through his counsel in the trial court, informing them that the matter will be taken up for disposal on so on.
13th December.
Released on so interim.
The
state.
stay of
13th December. Number 45. Srimati Sonia Rajesh.
The petitioner, Your Honor. MC petition of RCR has been filed by the respondent husband in the Honorable Court, Dharwad. Multiple cases has been going on in Bangalore by the wife, filed by the wife, that's maintenance and the domestic violence as well. 2 FIRs has been filed against the husband in Bangalore.
Counsel is permitted to take out notice in the respondent through his counsel in the trial court, informing him the matter will be taken up for disposal on so on. So.
13th December.
Interim state in them.
Stay on.
Number 46, Shri Chandan Goda Patil.
It's appearing for the petitioner in this matter. We are seeking for a transfer of GNWC proceedings, which is pending before the Bangalore Rural Court to the Family Court, my lords.
Bangalore in the Bangalore again.
Bangalore Rural, my lords. To Family Court, Bangalore, my lords.
Any other proceedings pending there?
Yes, my lords. There is one divorce petition pending there. Pending, my lords. That is
Issue notice. The petitioner is permitted to take out notice on the respondent through his counsel in the trial court, informing the matter will be taken up for disposal on so on. So. List on so on. So.
my lords, it may be tagged along with one more CP petition, my lords, which
Post
is
along with CP number.
429 of 2020.
Has somebody entered appearance in that CP?
No, my lords.
Who has filed the CP? You had filed?
I have one.
429 of 24.
429 of 20. Deeply obliged.
Number 47.
Your Lordship, I'm appearing for the petitioner in item number 47. My Lordship may kindly consider the issuance of citation in IA number 3 that I'm pressing, and IA number 2 I'm not pressing because of.
Since it is undertaken that the petitioner would pay the maximum court fee payable, notice to the Deputy Commissioner regarding the valuation of the assets is dispensed with. IA 2/24 is dismissed as not pressed. Issue a citation to be published. Earlier, other assets.
My lords, the asset is in Ghaziabad, and there is a newspaper in Ghaziabad which is prominently circulated, Amar Ujala, Meerut edition. I have mentioned it in the application.
ಯಾವ newspaper ಹೆಸರು ಕೊಟ್ಟಿಲ್ಲ?
I mentioned, my lords, Amar Ujala in my application, Amar Ujala, Meerut edition, Hindi newspaper in Ghaziabad.
They don't have Times of India or any other newspaper. Amar Ujala has circulation there.
Yes, Amar Ujala, very wide circulation in the western part of UP, entire UP actually, and prominently the Meerut edition, which is next city of the adjoining city of Ghaziabad.
Meerut edition, and also in the New Indian Express Bangalore edition, indicating the date of hearing as so and so. The citation should be published on or before
28th December, on or before 20th December. Date of hearing 17th January.
Grateful, madam.
For hearing B group, seal number 48.
I appear for the petition in the main matter. And the connected matter, my lords, also claims to be a grantee of a different survey number. But originally, my lords, what had happened was certain persons interfered with my land, saying that they had purchased it from the grantee. And then after inquiry, my lords, I got to know that another person claiming to have been granted in the year 1925 had approached AC court. So I got implicated in that case, saying that grant is illegal, and that in 1925, Bangalore South Taluk itself was not there, and that land could not have been.
You claim you're a grantee.
Yes, my lords. I also claim to be a grantee. Petition the connected matter also claims to be a grantee of 2 different years. That grant is a fraudulent grant is my claim, my lords, one of the claims.
What is the land survey number?
Minutes, originally, they interfered with my survey number 142, claiming that it is survey number 11. Tahsildar filed a report in the course of these proceedings that they are completely different. Old survey number 100 and my land arrests from old survey number 100.
Application for exemption was made in respect of which survey number?
Their application was filed against survey number 11. It came to be dismissed in favor of the purchasers. However, there was a
This number 11 application is dismissed.
dismissed.
Confirmed
However, there was a remark saying my grant is also illegal. So and it purchasers of the lands eventually succeeded.
The application for exemption by the grantees of survey number 11 was dismissed.
Dismissed.
Where is that order?
Means if I may narrate, there are certain events that has transpired further.
I need the basic facts. Application for exemption was dismissed.
Please, my lords.
Was it confirmed in appeal or was it reversed in appeal?
It was reversed by DC code, saying that grant is illegal in 1925, that land in relation.
Why would it be reversed if the application?
Because I challenged it, my lords.
The application for exemption is dismissed.
Dismissed.
If it's dismissed, the land stays with the purchaser. Correct?
But I am also a grantee. I am not a purchaser, my lords.
You did not make an application for exemption.
I did not make.
If you
Because
not-
I could not claim that I sold the land at all, so I could not make an application. I got impleaded.
No, if you are a grantee and if you have not alienated the land, the question of you invoking PT select will not arise.
Please, my lords. On the last date of hearing, my lords had indicated the same thing. But there are certain impediments for me to withdraw this petition also, because Deputy Commissioner finally in the second round of litigation has made has given a finding that my grant is illegal. If I go to civil court, my lords, with the bare injunction suit, that will come in my way. And the subsequent purchase has muted the RTC from my name to his name, my lords, and not from his purchase also. There are some difficulties, my lords, for me to simply sit and withdraw the case. If I may make one more submission, my lords, previously, before the coordinate bench, my petition was separately allowed, saying it's a separate land and I could make any corrections with the records, can make any application for correction of records. But however, at the instance of the purchaser, in writ appeal, my lords, my land was remanded. Sorry, my petition was remanded. So, giving division bench request to the single judge to dispose it off together, my lords. And my lords, so both petitions should be disposed of together, my lords. That is the direction.
The other petition.
It's connected, my lords.
This way the grantee, correct?
They also claim to be grantee. There is no advocate on record as of now, my lords.
Your Lordship, here it is mentioned that ಮೂಲ ದಾಖಲಾತಿಗಳನ್ನು ಸಲ್ಲಿಸಲು ವಿಫಲವಾಗಿರುವುದರಿಂದ. Page number 53. Will not produce the document to show grant certificate. Page number 53, your Lordship.
Which petition?
3688.
I am arguing from sir 2271.
This is also connected, no?
Connect ಆಗಿದೆ.
Same.
Different
survey
survey
number. Different survey.
number, but ಅದು ತಹಸೀಲ್ದಾರ್ ಈ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿದ್ದು ರೆಕಾರ್ಡ್.
Where is the order of the Assistant Commissioner? What is the date of the order of the Assistant Commissioner?
Page number 22, my lords,
In your writ petition?
in my writ petition. 14th March 2011, Annexure B.
Page?
22. In WP number 22712.
This was filed by P. Krishnappa, Narayan Swamy.
That is the
and,
petition in the
Gopal.
connected matter.
The application for resumption was rejected.
Yes, my lords.
Nevertheless, you preferred an appeal.
Because, yes, my lords, the problem was, my lords, the purchasers were interfering my property, claiming that is survey number 11. And since there was a AC order in their favor, I understand, my lords, where my lords are coming at. We preferred an appeal, and Deputy Commissioner restored the land in my favor, saying that the original.
Your name.
Please, my lords,
What is your
page
order?
number 33, my lords, I challenged, and Deputy Commissioner holding that his land is illegal, his grant is illegal.
No, he says you're also the petitioner before the Assistant Commissioner.
I got impleaded, my lords.
No, your father got impleaded,
Please, my lords,
Muni Venkatappa.
please.
So your father's application for resumption, along with the other applicants, was rejected.
Rejected.
And you therefore preferred an appeal.
Please, my lords,
And that appeal has been allowed.
in my favor.
Against which who has preferred a writ petition?
The petition in the connected matter preferred, and that is the next, at page number 86, my lords. This honorable court was pleased to remand.
The petitioners in connected matter are, who are they before the Deputy Commissioner? They are also the grantees.
No, I apologize, my lord. Could that question be repeated, my lords?
The petitioners in this WP,
In the connected matter.
yeah, PP Krishnappa by LRs.
Yes, my lords.
PP Krishnappa was before the.
He
was the
approached the
respondent.
assistant commissioner first, my lords. In his case, I got impleaded. My
he
father
was-
got impleaded.
He was the respondent purchaser.
No, but he also claimed to be a grantee. In the year 1928. Which was found to be illegal because saying that land, the grant recorded from Bangalore South Taluk. Bangalore South Taluk was bifurcated only in the year 1940. On that ground, my lords, his grant was found to be illegal and my grant was found to be correct and the land was restored in my favor. That was challenged in WP in writ petition on the ground that one of the party in person was not heard. It was
Where is
remanded.
the finding of the writ commission regarding your grant?
Please.
Because it simply says, resume the land and restore it to the original grantees.
Page number 81 and 82, my lords.
Nim case alla.
Nam case. The Deputy Commissioner's order. Para number 7 in page number 82, Bengaluru Dakshin Talaku. Goes on from para number 4, page number 81 and 82 minutes.
28/9/98.
Twenty-eight 1928 his is a grant that he claims.
To Muniga.
Both of them claim to be son of Muniga, my lords. Muniga, son of Muniga.
According to this order, 28/9/28, ಮಂಜೂರಾಗಿದ್ದು ಇದೇ ಜಮೀನನ್ನು 62 ಮುನಿಗಾ ಬಿನ್ ಮುನಿಗಾರ್ ಅವರಿಗೆ. It's a double grant another.
Double grant Allah Swami. It's an illegal, it's a fraudulent document because, or an illegal grant because it refers to Bangalore South Taluk in the year 1928. In the year 1928, there was no bifurcation of Bangalore South Taluk, North and South. It came only in the year 1940.
7, read para 7.
Bangalore Dakshin Talukku, ವರ್ತೂರು ಹೋಬಳಿ ದೊಡ್ಡಕಣೆಹಳ್ಳಿ ಗ್ರಾಮದ ಹೋಬಳಿ ಸರ್ ನಂಬರ್ 11 ರಲ್ಲಿ 5 ಎಕರೆ ಜಮೀನು ಮುನಿಗಾ ಬಿನ್ ಮುನಿಗಾ ರವರಿಗೆ 28/9/1928 ರಂತೆ ಮಂಜೂರಾಗಿದ್ದು ಇದೇ ಜಮೀನು 1962-63 ರಲ್ಲಿ ಮುನಿಗಾ ಬಿನ್ ಮುನಿಗಾ ರವರಿಗೆ ಸರ್ ನಂಬರ್ 140 ಯಲ್ಲಿ 5 ಎಕರೆ ಜಮೀನು ಮಂಜೂರಾದಂತೆ ಪ್ರಕರಣ ಸೃಷ್ಟಿಸಿಯಾಗಿದೆ. 1962-63 ದಾಖಲಾತಿಯಂತೆ ಮಂಜೂರಾಗಿರುತ್ತದೆ ಎಂದು ಪ್ರತಿವಾದಿಸಿರುವ ಸೃಷ್ಟಿಸಿದ ದಾಖಲೆ ಆಧಾರದಲ್ಲಿ ಹಕ್ಕು ಸಾಧಿಸುತ್ತಿರುವಲ್ಲಿ ವ್ಯಕ್ತಪಡಿಸುತ್ತದೆ. ಈ ಬಗ್ಗೆ 1928 ರಲ್ಲಿ ಮಂಜೂರಾದ ನಂತರ ಹೊಸ ಸರ್ವೆ ನಂಬರ್ 140 ರಂದು ದುರಸ್ತಾಗಿದ್ದು ಜಮೀನಾಗಿರುತ್ತದೆ. ಈ ಹಿಡುವಳಿ ಜಮೀನು 1963-94 ರಲ್ಲಿ ಮಂಜೂರು ಮಾಡಲು ಹೇಗೆ ಸಾಧ್ಯ ಆಗಿದ್ದು 1963-64 ಮಂಜೂರಾದಂತೆ ಹೇಳಿರುವುದು ಸುಳ್ಳೆಂತ. I'm sorry, the subsequent Deputy Commissioner's order. I'm sorry, page number 46 is the original first order of the Deputy Commissioner.
Why are you so confused about the facts?
I'm sorry, minutes. In minutes, I engage senior advocate minutes. Since you held up, I comments.
Let him tell you.
Facts really correct.
I've come to the first order of Deputy Commissioner, then it will be remanded, then again.
That's the
33, sir.
On the basis of a grant set to have been made in 1928, a sale transaction takes place.
Now you first give me the dates of the grant. 28/9/28 is 5 acres in survey number 11.
Yes.
Then what is the other grant?
Well, the other grant takes place in the year 1964. That is in our favor, in favor of the present petitioner.
What is the exact date?
What's the exact date? We have produced this grant certificate 28/8/1964.
28/8/1964. This is survey number?
Same survey number, my lords.
11.
140.
That's why I said in 28 survey number 11 was granted.
140. 140.
Shankar. The order.
Lords, 1928, they claim that this is survey number 11. And that transaction takes place pertaining to survey number 11 only. My property, which is granted annexure A, page 17, my lords, is pertaining to survey number 140, measuring 4 acres, 36 kuntas. Page 17 at page 18, my lords. Typed copy is at page 21.
Four acres 36 kuntal.
Yes. My lords, this survey number 140 is presently divided into 140/1 to 140/5.
In the name of?
Lords, this is granted in the name of Muniga bin Muniga.
Same gentleman.
Yes. Muniga, E Muniga bere, A Muniga bere. Ade samasya ಆಗಿರೋದು.
Same father name same ಇದೆ.
But ಇಲ್ಲಿ claim ಮಾಡ್ತಿರೋದು two different branches altogether, two different families altogether. The family of Muniga, which claims grant in the year 1928, is a different set of family for which they have contested.
You did not sell the land.
I have not sold the land.
Then this other Muniga's branch sold the land.
So they claim that the land is sold.
When?
Lords, this first sale comes into existence what is the date of sale? And notes good. I'll get my 5 notes, I think. My notes is in my file. So, please. Also, can I request for Monday minutes? Afternoon, there is some inconvenience because of a family function. Please. 6th, please.
Silver 49. Met Saukar. Silver 49.
Saukar.
Well, in this case, morning, in fact, there is a settlement. In fact, Punjab is also requested to, they will look for a settlement also. Your Lordship may kindly grant. It's a common order being passed. But I also requested the morning with regard to the time also.
6th December.
6th December.
Number 50. Jayanta Pujari.
Your Lordship,
Number
stand for
50.
court response.
First sale, my lord.
You're for the grantee or for the purchaser?
I am a purchaser.
Purchaser.
Please. Grant in the year 1956, my lord.
Yes.
First sale, my lord, on 15/7/1969. Thereafter, my lord, that is sold in favor of one Rudrappa. My lord, thereafter, on 19/4/1984, my lord, Rudrappa sold the property in favor of the petitioners in 2 sale deeds.
89.
89. 2010 application was filed for restoration.
What was the period of non-alienation in 56?
My lord.
What was the period of non-alienation in 56?
My lord, 10 years actually at that time of.
Where is the order of the Assistant Commissioner?
Annexure B, my.
15 ವರ್ಷ ಅಂತ ಇದೆ.
15 ವರ್ಷ ಅಂತ ಅವರು ಹೇಳ್ತಾರೆ.
So up to 70 it could not have been sold.
Please.
You said 10 years.
Yes, ma'am. That's what my contention. Yes. At that time of point of time, my lord, it is in all grant, my lord. It's 10 years.
What was the rule?
In 20, my lord, grant right.
Where is the order of grant?
Grant, my lord, annexure C, my. Wherein it's.
Annexure C na?
Yes, ಅದರಲ್ಲಿ 10 ಇದನ್ನ ಸ್ಟ್ರೈಕ್ ಔಟ್ ಮಾಡಿ 15 ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
ಇಲ್ಲ ಅದೇನು ಫ್ರೀ ಗ್ರಾಂಟಾ ಇಲ್ಲ ಅಪ್ಸೆಟ್ ಪ್ರೈಸ್?
ಇಟ್ಸ್ ಎ ಫ್ರೀ ಗ್ರಾಂಟ್.
15 years.
ಹೌದು, ಅಲ್ಲಿ 10 ವರ್ಷ ಅಂತ ಇತ್ತು. ಪೇಜ್ ನಂಬರ್ 21. ಅದನ್ನ ಸ್ಟ್ರೈಕ್ ಔಟ್ ಮಾಡಿ 15 ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಸೊ ಇಟ್ ಇಸ್ ಓವರ್ ರಿಟರ್ನ್ ಮಾಡಿ.
It's time for the 4th respondent.
Yes.
Your Lordships, either before the Assistant Commissioner or before the Deputy Commissioner, they do not take defense that the grant made, and before this honorable court, they have taken such a defense, Your Lordships.
Yenanta?
In fact, may I bring your Lordship's attention to page number 17 of the petition.
Yes.
Page number 17,
Yes.
paragraph number 2, Your Lordships.
Odi. Please read.
ಚಳ್ಳಕೆರೆ ತಾಲೂಕು ಪರಶುರಾಂಪುರ ಹೋಬಳಿ ವಿಸ್ತೀರ್ಣ ಜಮೀನನ್ನು ಚಳ್ಳಕೆರೆ ತಹಸೀಲ್ದಾರ್ ಅವರು ದಿನಾಂಕ 15/5/56ರಂದು ದೊಡ್ಡ ತಿಮ್ಮಯ್ಯ ಯಾನೆ ಯರ್ರಪ್ಪ page number 17, paragraph number 2, Your Lordships.
Internal page 2.
Internal page 2, ಹೌದು.
ಮೊದಲನೇ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಮೊದಲನೆಯದಾಗಿ ಪ್ರಶ್ನಿತ ಜಮೀನು.
ಅಲ್ಲ ಇದು ಎದುರುದಾರರ ಪರ ಲಿಖಿತವಾದ ಬಿಲೋ ದಟ್, Your Lordships.
Page number 18.
Page number 17.
ಇದು ಮಾಡಿ ದಾಖಲಾತಿಗಳ ಪರಿಶೀಲನೆ ಅಲ್ಲಿಂದ ಓದಿ ನೆಕ್ಸ್ಟ್ ಪೇಜ್. ಚಳ್ಳಕೆರೆ ತಾಲೂಕು ದಾಖಲಾತಿಗಳ ಪರಿಶೀಲನೆ.
ದಾಖಲಾತಿಗಳ ಚಳ್ಳಕೆರೆ ತಾಲೂಕು ಪರಶುರಾಂಪುರ ಹೋಬಳಿ ಅರವಿಗೊಂಡನಹಳ್ಳಿ ಗ್ರಾಮದ ರೀಸರ್ವೆ ನಂಬರ್ 80P ರಲ್ಲಿ 8 ಎಕರೆ 24 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣದ ಜಮೀನನ್ನು ದರಖಾಸ್ತಿನಲ್ಲಿ ದೊಡ್ಡ ತಿಮ್ಮಯ್ಯ ಯಾನೆ ಯರ್ರಯ್ಯ ಇವರಿಗೆ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಚಿತ್ರದುರ್ಗ ಇವರ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ಉಚಿತ ಮಂಜೂರಾತಿ ಮಾಡಿರುತ್ತಾರೆ. 15 ವರ್ಷಗಳ ಪರಭಾರೆ ಮಾಡಬಾರದು ಎಂಬ ಷರತ್ತು ವಿಧಿಸಿ ಸಾಗುವಳಿ ಚೀಟಿ ನೀಡಿರುತ್ತಾರೆ. ತಹಸೀಲ್ದಾರ್ ಚಳ್ಳಕೆರೆಯವರು ಅರ್ಜಿದಾರರು ಆದಿ ಕರ್ನಾಟಕ ಜಾತಿಗೆ ಸೇರುತ್ತಾರೆ ಎಂದು ಜಾತಿ ದೃಢೀಕರಣ ಪತ್ರ ನೀಡಿರುತ್ತಾರೆ. In the previous page, Your Lordships, the petitioners themselves admit that the non-alienation period is for 15 years. Even yes. Before the Assistant Commissioner, they make an admission, similar admission.
No matter what they say, read the whole.
ಪ್ರಶ್ನಿತ ಜಮೀನು ಮೊದಲನೆಯದಾಗಿ ಮೂಲ ಮಂಜೂರಿದಾರ ದೊಡ್ಡ ತಿಮ್ಮಯ್ಯ ಯಾನೆ ಯರ್ರಯ್ಯ ಇವರಿಂದ SR ಸೋ ಅಂಡ್ ಸೋ ರಲ್ಲಿ ಜಿ ರುದ್ರಪ್ಪ ಬಿನ್ ತಿಪ್ಪೇರುದ್ರಪ್ಪ ಅರವಿಗೊಂಡನಹಳ್ಳಿ ಗ್ರಾಮ ಇವರಿಗೆ ಪರಭಾರೆಯಾಗಿರುತ್ತದೆ. ಪುನಃ ಇವರಿಂದ SR ಸೋ ಅಂಡ್ ಸೋ ರಲ್ಲಿ 4/12 ಹಾಗೂ SR ಸೋ ಅಂಡ್ ಸೋ ರಲ್ಲಿ 4/12 ಎಕರೆ ಜಮೀನು ಕ್ರಮವಾಗಿ ಅರವಿಗೊಂಡನಹಳ್ಳಿ ಗ್ರಾಮದ ಬಿ ಮಂಜುಳಮ್ಮ ಕೇರ್ ಆಫ್ ಲಿಂಗಪ್ಪ ಹಾಗೂ ದಾಕ್ಷಾಯಣಮ್ಮ ಕೇರ್ ಆಫ್ ಚಂದ್ರಣ್ಣ ಇವರಿಗೆ ಕ್ರಯವಾಗಿರುತ್ತದೆ. ಹಾಲಿ ಇವರ ಖಾತೆ ಹಾಗೂ ಸ್ವಾಧೀನ ಅನುಭವದಲ್ಲಿ ಇರುತ್ತಾರೆ. ಪ್ರಶ್ನಿತ ಜಮೀನು 1956 ಸಾಲಿನಲ್ಲಿ ಉಚಿತವಾಗಿ ಮಂಜೂರಾಗಿದ್ದು ಮೈಸೂರು ಲ್ಯಾಂಡ್ ರೆವಿನ್ಯೂ ಕೋರ್ಟ್ ಕೆಳಗೆ ರಚಿತವಾದ ಸರ್ಕಾರಿ ಆದೇಶ ಸರ್ವೆ ಸೋ ಅಂಡ್ ಸೋ ನಂಬರ್ ದಿನಾಂಕ 6/7/1955 ಕೆಳಗೆ ಪ್ರಕಟಣೆಯಂತೆ ಉಚಿತವಾಗಿ ಮಂಜೂರಾದ ಜಮೀನಿಗೆ 15 ವರ್ಷ ಪರಭಾರೆ ಮಾಡಬಾರದು ಎಂಬ ಷರತ್ತು ಇರುತ್ತದೆ. ಈ ಜಮೀನಿಗೆ ಈ ಷರತ್ತು ಅನ್ವಯವಾಗುತ್ತದೆ. ಮೊದಲನೆಯದಾಗಿ ದಿನಾಂಕ 15/7/1969 ಕ್ರಯವಾಗಿದ್ದು ಮಂಜೂರಾದ 13 ವರ್ಷ 3 ತಿಂಗಳು 24 ತಿಂಗಳ ದಿನಗಳ ಅವಧಿಯಲ್ಲಿ ಪರಭಾರೆ ಆಗಿರುತ್ತದೆ.
What is there to show it's a free grant? Does the grant certificate say that?
They have not paid any kimmat, Your Lordships. There is no payment of any price with respect to the grant land.
If it's a free grant, then it is 15 years, isn't it?
Yes, Your Lordships.
Page number 21 ಅಲ್ಲಿ ಅದರಲ್ಲಿ ಬಾಟಮ್ ಅಲ್ಲಿ 10 ವರ್ಷ ಅಂತಿದೆ.
What is the rule prevailing? Is it a free grant or is it a grant on an upset price?
It's a free grant as per the grant order.
Then 15 years, isn't it? The rule is 15 years, no matter what is written there.
Please. I will go through that rule and all.
Then madam, then free grant upset price.
File is not there, Your Lordship. Kindly may be taken up.
And you yourself said it is 15 years. ಯಾವ್ದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದು?
2010, 19/1/2010. After 41 years.
30 years ಆದ್ಮೇಲೆ ಹಾಕಿದಿರಾ ಭಾರ್ಗವ್?
But your lordship, that Nekanti's judgment does not apply to this case because
Why?
your lordships, in that the Honorable Supreme Court only discusses matters where sale has been done after expiry of non-alienation period. They do not discuss about sale which was done prior to expiry of
No matter
non-alienation.
what, you should make an application within a reasonable time. 30 ವರ್ಷ ಆದ್ಮೇಲೆ ನೀವು
No, the first sale itself is void, your lordships. No right could be transferred.
If you go by the first sale, you challenge it after almost 40 years.
No, actually, in my case, Manchegowda's case should apply, your lordships. Nekanti's wouldn't apply to my case.
ಮಂಚೇಗೌಡ ಅಪ್ಲೈ ಆಗುತ್ತೆ, but provided you seek for resumption within a reasonable time. You can't wait for 30 years.
No, fourth respondent's claim has always been that he's been possession of the property, had no idea about the entire transaction.
ಆಯ್ತು ನೋಡ್ರಿ ಅದೇನಾಗುತ್ತೆ ಕರೆಕ್ಟ್ ಮ್ಯಾಟ್ರ್, ಚಾಲೆಂಜಿಂಗ್ ವ್ಯಾಲಿಡಿಟಿ, ರಿಲೀಸ್ ಆಫ್ಟರ್ 4 weeks.
Much obliged.
51 to 61 adjourned. Number 62, Madhukar Nadik. Number 62.
ನೀವು ಯಾರಿಗೆ? 52 60 ಅಲ್ಲ 62 51 52 minutes ಎಲ್ಲ ಅಡ್ಜರ್ನ್
Adjourn ಮಾಡಿದ್ರು.
51 to 61.
62 I am
62
respondent,
ಏನ್ ಗ್ರಾಂಟಿಗ ಪರ್ಚೇಸ್
grantee.
ಏನ್ ಗ್ರಾಂಟ್ ಏನು?
No, grant, my lord, they say that, my lord, there is a will executed by grantee in favor of third person. And, my lord, there is a decree obtained by her on the basis of the will. And therefore, our contention is it is a will, if it is executed in favor of family members, my lord, then it is saved. Otherwise, if it is a third person, there are judgments of this honorable court holding that.
Can you call it an alienation? Can you call it an alienation?
Yes, it is a transfer.
Transfer ಬೇರೆ.
No, there is a presumption under the act.
No.
If other than original grantee or his legal heirs is in possession of
ಬೇರೆ
the,
ಪ್ರಶ್ನೆ.
no, that is my lord. Will is excluded under the definition of transfer. But
it is
here it is in favor of some third person. Not to avoid the provisions of the act, will is executed.
ಯಾವಾಗ ಬಿಲ್ಲು?
Will is, my lord,
ಗ್ರಾಂಟ್ ಯಾವಾಗ? When was the grant?
grant, my lord, there is violation. That is, there is no dispute on that.
When
The
is the
only
grant?
question is,
When is the grant?
grant, my lord, grantee is, not 88, 98, 99. It is by way of regularization, 98, 99. My lord, the original grantee was in unauthorized cultivation. And it was regularized, that unauthorized cultivation was regularized in 98, 99.
Now, I have already taken the view that if it's regularization, then it is not a granted land.
No, it is a granted land. No, it is ultimately, my lord, the under section 94A, a person who is in unauthorized cultivation is entitled for a grant by regularizing the unauthorized cultivation.
But that is not because he belongs to scheduled caste or scheduled tribe. Every person in unauthorized position is entitled for regularization. For a granted land to a person who belongs scheduled caste, scheduled tribe, because he belongs scheduled caste, scheduled tribe, then there is this alienation period, not otherwise.
He is a scheduled caste person.
He may incidentally happen to be a scheduled caste.
Yes.
But it can't be a granted land.
My lord, we will go by, my lord, the definition of granted land occurring under this enactment.
Go by that
So,
definition.
Yes,
It means it's a land granted to a scheduled caste or scheduled tribe person.
yes.
For that to apply, under the land grant rules, certain lands are earmarked for grant to scheduled caste, scheduled tribe persons. Only those lands can be granted to them.
That is not, my lord, my respectful submission is. So we have to see the object and intent of the act. My lord, while regularizing the land by way of grant, my lord, a rider is imposed that it shall not be alienated for a period of 20 years. My lord, within the prohibited period, my lord, grantee executes a will. That is to see that the act is not my lord, applied in future. So my submission is merely, my lord, which of the Land Reforms Act, my lord, this court held that in respect of a grant of occupancy right, my lord, this honorable court took a view that those the occupancy rights granted cannot be construed as a granted land under this enactment, because a tenant, he got the occupancy right because of his pre-existing interest, that is as a tenant.
The same
Yeah,
principle
yeah,
applies.
that is, but here it is not so. So
He's been granted land because of his occupation unauthorizedly prior to the order. It is on the same analogy of Form 7.
my lord,
Can't be different.
my lord, there are, my lord, there are any number of judgment of this court.
Full bench says Form number 7, if you file and is granted to you, is granted because you are in possession as on that particular date, appointed date. Not because you belong to scheduled caste. You may incidentally belong to scheduled caste. Every person was in possession of somebody else's land as on 1374 is entitled
My
to
lord,
be.
under this act, the definition of my lord, granted land, it doesn't say that, my lord, the grant must be, my lord, earmarked for persons belonging to scheduled caste. If land is granted.
That is the whole
only,
purpose.
no, that is not, my lord.
You see the statement of objects and reasons?
No, my lord, in the kindly, my lord, granted land. Definition. Means any land granted by the government. 2B.
ಏನಕ್ಕೆ ಪೂರ್ತಿ ಓದಿ.
Any granted land means any land granted by the government to a person belonging to any of the scheduled castes or the scheduled tribes, and includes land allotted or granted to such person under the relevant law for the time being in force relating to agrarian reforms or land sealings, abolitions, other than that relating to hereditary offices or rights, and the word granted shall be construed accordingly. Well, this is
It includes land granted under the relevant law.
Yes.
Agrarian reforms.
Yes.
Therefore, it should be a land grant on the basis that
No,
you
no,
belong to.
relevant law for the time being in force relating to agrarian reforms or land sealings or abolition of inams, other than, those are excluded. Suppose, my lord, it is a inam land. Inam land, my lord, if there is a grant, re-grant, that is not, my lord, that is excluded from the purview. So therefore, from the language couched in this provision, if a land is granted by the government in favor of a person belonging to either scheduled caste or scheduled tribe, well, it is a granted land. My lord, this contention is not taken. The contention taken is, my lord, the bequest is not a transfer.
That is
That is
second aspect. But if fundamentally PTC Act is inapplicable, then whether it's a
My lord,
bequest or a sale,
there
it's
are-
of no
No,
consequence.
then I have to, my lord, I have to.
See the
This
statement
this
of
is not the
objection.
contention raised anywhere, either before.
Read the statement of objects and reasons.
Yes. Statement of.
Statement of objects and reasons. Note.
The non-alienation clause contained in the existing land grant rules.
Land grant rules.
Land grant rules.
The
And the provisions. No, there are rules, my lord.
no. See this, the non-alienation clause contained in the existing land grant rules.
Rules.
And the provisions for cancellation of grants where the land is alienated in contravention. So this indicates only if it's a land granted under the land grant rules.
Yes, it is also under land.
This is under section 94, which is.
But again, rules are framed, my lord. 94A only says, my lord, a person in unauthorized cultivation, He is entitled for my lord, he shall not
That
be.
is not a land earmarked for scheduled caste, scheduled tribe. Under the land grant rules, 50% of the lands are to be earmarked for scheduled caste, scheduled tribe. Not all lands are granted to scheduled caste, scheduled tribe. Only those lands which are granted for SC, ST, if there is a violation of terms of the grant, then this act will apply. Not all lands.
No, my lord.
That's why the act uses the word certain lands.
Certain land, my lord, that is certain land means the land, my lord, granted to scheduled caste, scheduled tribes with a condition.
Under the
With a
existing,
condition.
under the existing land grant rules.
My lord, my lord.
Land grant rules.
Yes, this is also under, my lord. No, 108 rules are framed
Yeah,
for the
that is-
purpose
that's
of
not under the land
94A,
grant rules.
94B.
That is not under the land grant. Those are rules framed under the Land Revenue Act
Yes, my lord.
to regularize possession of all persons.
Yes, my lord. Land grant
Irrespective of,
rules also, my lord, under again, land grant rules, my lord, from 68 onwards, my lord, 68. The grant rules were framed under the act itself. In exercise of power, my lord, the rules are framed by the government.
a grant indicates that nobody had inherit over that particular land. The government had absolute rights over that, that is granted. If somebody was in possession and the law creates a particular right to regularize their possession, you can't bring it within the ambit of the land grant rules.
There are difference. My lord. Encroachment, a person has encroached, my
Then
lord, it can't be said that he has got an interest in the land. Whereas, my lord, a tenant under Land Reforms Act, he has got a right, my lord, a pre-existing right to seek for grant of occupancy right. That's why the
Same
division bench
principle,
of this court
same
said,
principle under the Land Revenue Act. If you are in possession of the government's land prior to a particular date, you are entitled to seek for and be granted an order of regularization. That is,
order of
that is
grant.
on the same analogy of form number 7.
My lord, if I am in unauthorized cultivation, I am an encroacher of a government land. My lord, section 94, otherwise I am liable to be evicted.
Even a tenant, he has no right to be in possession. He is liable to be evicted by the landlord.
No, he is not liable for it.
Why not?
My lord, he has
But
to.
for the, but
No,
for the Land
he
Reforms
has
Act,
to apply for, my lord.
but for the Land Reforms Act, he had no right to be in absolute possession, continued possession, but for the land grant rules. What is his right?
My lord, under Land Reforms Act, my lord, the tenant had got the protection before 1974 amendment.
If you take away the
Before
land, if
74
you take
amendment.
away the Land Reforms Act, he has no protection
Where, my lord?
under the Land Reforms Act.
Yes, my lord, there was a protection prior. 74 amendment, drastic amendment were brought to see that, my lord, a tenant cultivating the land as on 1/3/1974 and immediately prior to that shall be, my lord, granted, the occupancy right shall be granted on him. That is to see that a tiller of the land becomes the owner of the land. That is, my lord, to the.
Only difference is under the Land Reforms Act. That land belongs to a private person.
Yes.
This land grant rules, the land belongs to the government. For both of them, the difference is subtle and yet different. Under the land grant rules, the land belongs to the government. So therefore, the government, as the owner of the land, can do whatever it wants.
My lord, respect, my lord. Even a land, my lord, a government cannot give a private land to another tenant. What, my lord, there is by operation of law, any land in the possession, cultivation of a tenant who is in lawful possession as on 1/3/1974 and immediately prior to that, my lord, it vests with the government free under section 44. Once land vests with the state, then of course, my lord, the occupancy right can be conferred on an application made by tenant.
His right to seek for occupancy is based on his pre-existing possession.
Yes, he
He's
must
in
be in
possession
possession.
of somebody else's land. Section 4 of the Land Reforms Act creates a deemed tenant status on him. He doesn't have to be an actual tenant. He's deemed to be a tenant for the purpose of the Land Reforms Act. So the reason for granting occupancy rights is his possession of that particular property. The same principle will apply for unauthorized possession also. The reason for granting the land is because of his unauthorized possession.
My lord, all are not given, my lord. The unauthorized, all unauthorized cultivators, the encroachers of the government land are not entitled for regularization. My lord, there are certain conditions, if they satisfy that condition. My lord, ultimately, my lord, there is a lot of difference between a tenant under Land Reforms Act and an encroacher under, my lord, the Land Revenue Act. My lord, that requires, this, my lord, contention is not, my lord,
I've already taken the view
No, there are 2, 3 other points in this case. my lord.
ಇದು one point ತೊಗೊಳ್ಳಿ first.
ಅಲ್ಲ ಇದೆಯಲ್ಲ ಇದು ನಾನು today my lord it is.
ಈ point already taken, today also I disposed of one matter.
No, he has never taken this contention.
Other case also I took up the plea, they took up the
Well,
plea.
there are many cases, my lord, under this regulation. There are thousands of cases entertained by even by this court.
This court is taking a different view. The judgment is there.
ಯಾವತ್ತು?
And next week ಬನ್ನಿ ನೋಡೋಣ. Realist. 6.
Well, not next week, my lord, any day of. Next week I am not in station.
13th.
13th.
Number 63, Jagdish Achari, appeal for the petitioner, I am the grantee, your last minute, 19/8/1955, minute.
ಎರಡು ರೇಟ್ petition ಯಾಕೆ?
Sorry?
Why 2 ರೇಟ್ petitions? Grantees. both of
Yes,
them are-
same order, same order.
Yes.
19/8/1955, minute, grant. Sold, minute, 14/5/1965.
Yes.
15 years, minute, the assistant commissioner, minute, restored the said land to me, grantee.
ಯಾವ್ದು application ಹಾಕಿದ್ರಿ ನೀವು?
Minute,
We need to make the application for resumption. We need to make the application for resumption.
2009, 2009.
30 years.
After, minute, 2009, restore the,
After 30 years.
Because it was considered by the purchaser, he said that land is taken back. He filed a memo before the actual.
and also, minute, your last, after 11 years, the respondent kept quiet. After, in 2009, minute, the order, yes, order. 2019, he filed a deputy commission filed a application, review, RP. You are like, yes, appeal, minute, appeal filed by against assistant commissioner before the DC.
Where is the order of the AC? Dismissing the appeal as considered. Where is that order? Where is it said that he conceded?
Yes. Your Lashma, annexure A, page number 19, 17. Our your Lashma, our only your Lashma, my client name is your Lashma, Rama alias Chiktim Rayappa. Minute the deputy commission taken a contention. Rama bere Chiktim Rayappa bere and Raman ge grant agirodu Chikrim Tim Rayappa.
Where is he conceded? Where is he conceded? No, where does he refer to in the order of the assistant commissioner?
Page number 43, minute, annexure H. Annexure H. Second paraminute.
Next, sir.
Yes, yeah. In
page number 44, minute. Last line is, ಇವರು ಆಕ್ಷೇಪಣೆಯನ್ನು ಇರುವುದಿಲ್ಲ ಎಂದು ಪ್ರಮಾಣೀಕರಿಸಿರುತ್ತಾರೆ ಅಂತ ಇದೆ.
Second paraminute, page number 43, second para. Your last minute. ಪ್ರತಿವಾದಿಗಳು ದಿನಾಂಕ 7/9/2009 ಮೆಮೊ ಮತ್ತು ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ಸಲ್ಲಿಸಿ ದೇವನಹಳ್ಳಿ ತಾಲೂಕು ಚನ್ನರಾಯಪಟ್ಟಣ ಹೋಬಳಿ ಅಂದ್ರಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 216ರಲ್ಲಿ 2 ಎಕರೆ ಜಮೀನನ್ನು ಅರ್ಜಿದಾರರಿಗೆ ಕರ್ನಾಟಕ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಪರಿಶಿಷ್ಟ ವರ್ಗದ ಹಲವು ಜಮೀನುಗಳ ಪರಭಾರಿ ನಿಷೇಧ ಕಾಯ್ದೆ ಪ್ರಕಾರ ಮಂಜೂರಿ ಮಾಡಲು ಇವರ ಆಕ್ಷೇಪಣೆ ಇರುವುದಿಲ್ಲವೆಂದು.
Purchaser filed a memo, is LR's filed an appeal.
He's after the death of purchaser, his wife and son from the appeal left of 11 years. Telling me the other day. The actual commissioner applies that the grant itself is, though the grant is not disputed in the petition, appeal dispute.
Where is the appeal memo filed by them?
ಅದು
62. ಯಾವ writ petition? ಯಾವ writ petition?
Grant is admitted, my lord, everything is admitted. They say that, my lord, it is, restoration was sought after lapse of 50 years. And no notice was issued on them. The father has represented. For the RTC holder.
Who appears for them? Who appears to the grantees, purchasers?
Somshekhar KH.
ನೀವಿದ್ದೀರಾ?
ಸರ್ ಅವರೇ ಸರ್
64 ಅಲ್ಲಿ
63, 64.
ಹೌದು. Lord, this is I find objections, Lord, in this matter.
In your appeal, you admit that the land is granted land.
It's not a granted land, but not in favor of Lord who have purchased property from Timrayap.
Your predecessor in interest. This.
There are two set of petitions, Lord. There are two wives of same order. One set of the party is not filed, Lord, petition before the Assistant Commissioner.
Where is the order of the Assistant Commissioner? Next year? Page 43.
ಯಾವ್ದ್ರಲ್ಲಿ? ಯಾವ ಮ್ಯಾಟರ್ ಸರ್ ನಿಮ್ದು? ಯಾವ ಮ್ಯಾಟರ್? ಅಲ್ಲ, ಯಾವ್ದ್ರಲ್ಲಿ? ಯಾವ ಪಿಟಿಷನ್?
First, Tamanna was the respondent in the Assistant Commissioner. Tamanna was the respondent to the Assistant Commissioner.
Yes, my lord.
Considered that it is a granted land, that the alienation was made in violation of the terms of the grant, therefore he had no objection for assumption. Correct? Then you are the LRs. How can you file an appeal?
Lord,
after your husband had conceded?
Lord, the Tamanna, when make an application, file a memo before the Assistant Commissioner, actually he was not feeling well. He was in dementia.
How many years?
ನಾನು produced the medical certificate also. ಅವರು ಹಾಕಿಲ್ಲ, ಅವ್ರು ಮೆಮೋನ ಹಾಕಿಲ್ಲ, ಯಾರು he was not feeling well. He was admitted in the hospital 2004 ಇಂದ he was in dementia. ಅವ್ರಿಗೆ ಏನು ಆಗ್ತಾ ಇದೆ ಅಂತ ಗೊತ್ತಿರಲಿಲ್ಲ. I produced the medical certificate also. 2004 ಇಂದ ನಾನು lordship kindly see my medical certificate produced in my objection statement.
In 2013 ಅಲ್ಲಿ. The order of the Assistant Commissioner was when? 2009.
Lordship kindly see my medical certificate.
R1.
R1. From 2004.
ಎಲ್ಲಿದೆ 2004 ಅಂತ?
ಒಂದು ನಿಮಿಷ ತೋರಿಸಿ ಸ್ವಾಮಿ, ಇದು ಹಿಸ್ಟ್ರಿ ಅಂತಿದೆ. KCO ಡಿಮೆನ್ಷಿಯಾ 2004 ವಾಸ್ ಟ್ರೀಟ್ಮೆಂಟ್ ನಡೀತಾ ಇದೆ ಅವ್ರಿಗೆ 2004ರಿಂದ.
He was admitted only in the year 2013.
ಅಲ್ಲ 13, ಬಟ್ he was 2004 ಇಂದಾನೆ ಡಿಮೆನ್ಷಿಯಾ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲ, ನೀವು ಅದಕ್ಕೇನಿಲ್ಲ ರೆಕಾರ್ಡ್ ಇಲ್ಲ ಡಿಮೆನ್ಷಿಯಾ ಅನ್ನೋದು.
ಅಲ್ಲ ಬರ್ದಿದ್ದಾರೆ, ಇಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ. ಹಿಸ್ಟ್ರಿ ಎಲ್ಲ ಇದೆ. ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ನೆಸ್ ಹಿಸ್ಟ್ರಿ ಎಲ್ಲ ಇದೆ. ಬ್ರೀಫ್ ಹಿಸ್ಟ್ರಿ ಅಂಡ್ ಫಿಸಿಕಲ್ ಅಂಡ್ ಅಡ್ಮಿಷನ್ಸ್ ಇದೆಲ್ಲ ಅದರಲ್ಲಿ ಕೆಳಗಡೆ ಡಿಮೆನ್ಷಿಯಾ ಫ್ರಮ್ 2004.
From 2004 he was unable to move around. He was not able to understand. ಅದನ್ನ ಕೊಡಿ. ಯಾವುದೋ ಒಂದು ಪಾಸ್ ಹಿಸ್ಟ್ರಿಯಲ್ಲಿ ಬರ್ದ್ಬಿಟ್ಟು he was on medication. He would have been normal.
I'll put it the exact appeal.
No such contention was taken before the Deputy Commissioner in the appeal, their own appeal. No such contention is.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಆಕ್ಚುಲಿ ಇವರು ಅವ್ರ ವಾರಸದಾರರು ಅನ್ನೋದಕ್ಕೆ they have not produced any document to show.
ಬೇರೆ ಪ್ರಶ್ನೆ.
And number 1, number 2,
ಮೆರಿಟ್ಸ್ ಮೇಲೆ ನೀವು ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂತ. Once your husband said allow the application for exemption, I cannot accept.
But that I disputed. That memo itself I am disputing.
How can you dispute after he died? He did not dispute the memo till he was alive. I can understand if he was alive and then you make an application.
Only
produce records.
Legal aids came to know only after his demise. I'll produce the document.
ಅವ್ರು ಬದುಕಿದ್ದಾಗ ಅರ್ಜಿ ಹಾಕಿ ನಾನು ನೋಡ್ರೆ ನಮ್ಮ ಯಜಮಾನ್ರಿಗೆ ಹಿಂಗೆ ತಲೆ ಕೆಟ್ಟಿತ್ತು, ಈ ತರ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಆರ್ಡರ್ನ ರೀಕಾಲ್ ಮಾಡಿ ನಮ್ಮ ಯಜಮಾನ್ರ ತಂದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ.
ಅವ್ರು ಗೊತ್ತೇ ಆಗಿಲ್ಲ ಪಾಪ, ಅದಕ್ಕಾಗಿ ಅವ್ರು ಅಪೀಲ್ ಹಾಕಿಲ್ಲ. ನಾನು ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್
ಗೊತ್ತಾಗ್ಬಿಡ್ತು.
ಆಮೇಲೆ ಇವ್ರು ಸ್ವಾಧೀನ ಬರಕ್ಕೆ ಶುರು ಮಾಡಿದ್ರೆ ಅವಾಗ ಗೊತ್ತಾಯ್ತು ಅವ್ರಿಗೆ. ಅಲ್ಲಿವರೆಗೂ ಗೊತ್ತೇ ಇಲ್ಲ ಅವ್ರಿಗೆ. I'll produce the document. I'll produce the medical certificate.
Next Thursday. final.
ನೆಕ್ಸ್ಟ್ 2 weeks ಟೈಮ್ ಯಾಕಂದ್ರೆ ಅದು
No, no, Monday, you are last Monday, my lord.
ಇವತ್ತೇ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ. ನೀವೇನೋ ಟೈಮ್ ಕೇಳ್ತೀರ ಅಂತ Thursday ಹಾಕೊಳ್ತೀನಿ ಅಷ್ಟೇ.
ಅಲ್ಲ ಮೆಮೋ ಮಲಾಡ್ ಸಿ ಲಾ ಪ್ರಿವೇಲ್ಸ್ ಓವರ್ ಮಲಾಡ್ ವಾಟ್ ಮಲಾಡ್ ದಿ ಅದರ್ ಮಲಾಡ್
Law is this, if you say,
ವೆದರ್
if you say before the assistant commissioner that the land can be resumed, I have no objection. After you die, your wife and children can't come and say, no, that order is wrong. I recall that order.
ಸ್ಟೇಟ್
You
ಆಫ್
cannot say that.
ಸ್ಟೇಟ್ ಆಫ್ ದ ಪಾರ್ಟಿ ಮಲಾಡ್ ಆನ್ ದಟ್ ಡೇ
You could not have got a right at all.
ಸ್ಟೇಟ್ ಆಫ್ ದಟ್ ಪಾರ್ಟಿ ಆನ್ ದಟ್ ಡೇ ಮಸ್ಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಲುಕ್ಡ್ ಇಂಟು ಮಲಾಡ್ ಆಲ್ಸೋ ಮಲಾಡ್.
He will say that he should have said that. Or when he was alive, he should have come to the court and said, ಈ ತರ ಮೋಸ ಮಾಡಿಸ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದ ನಮ್ಮ ಯಜಮಾನ್ರಿಗೆ ಅವ್ರ ತಲೆ ಕೆಟ್ಟಿತ್ತು ಅಂತ. ನೀವು ಸಾಯೋರು ಕಾಯ್ಕೊಂಡಿದ್ದು ಅವ್ರ ಸತ್ ಎಷ್ಟೋ ವರ್ಷ ಆದ್ಮೇಲೆ ಬರೋದು, ಇದು ರೋಲ್ ಕಾಲ್ ಕೇಸ್.
ಅಲ್ಲ ಪಾಪ ಅವ್ರು ದುಡ್ಡು ಕೊಟ್ಟು ಕೊಂಡ್ಕೊಂಡಿರೋ ರೋಲ್ ಕಾಲ್ ಅಲ್ಲ, ಅವ್ರು ದುಡ್ಡು ಕೊಟ್ಟು ಕೊಂಡ್ಕೊಂಡಿರೋರು ವಿದ್ಯಾರ್ಥಿ ಪರ್ಚೇಸ್ ಸರ್.
ವಿಡ್ರಾ ಮಾಡ್ಕೋಬಾರ್ದಾಗಿತ್ತು ನಿಮ್ಮ ಯಜಮಾನ್ರು.
ಅದು ಯಾವ ಆಂಗಲ್ ಅಲ್ಲಿ ಆಗಿದೆ ಅಂದ್ರೆ ದಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಲುಕ್ಡ್ ಇಂಟು. Otherwise, we could not have filed an appeal.
ಎಲ್ಲ ಒಂದೇ angle.
We could not file an appeal before the deputy commissioner.
He would have taken the money, therefore he withdrew the application.
ಯಾರ ಕಡೆ ದುಡ್ಡು?
No objection.
ಯಾರ ಕಡೆ ದುಡ್ಡು?
ನಿಮ್ಮ ಯಜಮಾನ್ರು ಕಾಸು ಇಸ್ಕೊಂಡು ಹಾಳಾಗಿ ಹೋಗ್ಲಿ
ಇಲ್ಲ, ಯಾರು ಕಾಸು ಕೊಡ್ತಾರೆ? ಕಾಸು ಇಲ್ಲಾದ್ರೂ ಕೊಡ್ತಾರ ಸ್ವಾಮಿ, ಒಳ್ಳೆ ಕತೆ.
ಇಲ್ಲ ಸುಮ್ನೆ ಹಳ್ಳಿಯವರು ಬಂದ್ಬಿಟ್ಟು ಆಯ್ತು ಸ್ವಾಮಿ ತಗೊಂಬಿಡಿ ಜಮೀನ್ ಅಂತಾರ. ಸೋಮಶೇಖರ್ ನಿಮ್ಗೂ ಗೊತ್ತು ನಂಗೂ ಗೊತ್ತು ಹೆಂಗಾಗುತ್ತೆ ಇವೆಲ್ಲ ಅಂತ. ಯಾರಿಗೊಂದು ಜಮೀನು ಬಿಟ್ಕೊಡ್ತಾರ, ಅದು ಹಳ್ಳಿಯವರು. Next Thursday.
Number 64, Shri Hegde Ramakrishna. For final hearing, seal number 66, Srimati Anne Mary Green.
This petition is for letters of administration with the will annexed, my lord. And I have filed the affidavit of the attesting witness. And I've examined even the petitioner who is the agent of the petitioner. Petitioner is the son of the deceased.
Petitioner son of the deceased.
Son of the deceased. And he has been represented by the GPO holder, my lord. The first GPO holder during the proceedings expired due to COVID, and subsequently the second GPA was executed, and it has been filed on 6/4/22, my lord, along with the death certificate of the agent.
What is there to show that he is a son?
The will, my lord.
Apart from the will, is there anything else to show that he is a son?
No, my lord. The will says that he's been appointed my son.
Yes.
I am appointing my son.
He has no birth certificate, nothing?
No, my lord. There's not, the mother has filed the,
No, but is there any document to show that he is a son?
no, my lord. There's no document to show that he is a son, but he is a executor. He's been executor trustee of the will. Whether he is a son or not a son, the executor and trustee of the will has to file the petition for probate or
You know, but
letters
is there-
administration.
have you produced any document to show that he is a son is what I'm asking?
No, my lord. The deceased had assets in Australia as well as in India. So this is the petition only with regarding to the estate in India, my lord.
He's got letters of administration there.
He would have applied for his this thing, but he has not served a copy to us. This will he has given to the Indian estate only.
Can you find out whether he
There's
has-
only one property in Bangalore, my lord, and in India of the deceased. This is located in Thomastown, Bangalore. I've also filed the amended petition as per the order on
Who are the attesting witnesses?
one attesting witness, my lord. Rosemary Croach.
What about the other one?
I have not filed the affidavit. One attesting witness is sufficient for probate or letters of administration. I have produced only one witness. And she has filed an affidavit stating the fact that she has seen the testator affix his signature along with the other other witness. A sworn affidavit has been filed along with the petition.
When was the citation made?
Citation was made in the on 17/4/2021, my lord, in Vijay, Karnataka, and in the Hindu on 8th April 2021. There has been no objection so far, my lord.
Gordon Noel Brown, son of Kathleen Eva Brown, no?
Gordon, he is the son now. He's represented by the GPA holder.
The testator is Kathleen Eva Brown,
Yes, my lord.
son of Kathleen Eva Brown, has filed this petition seeking for grant of letters of administration in respect of the estate of Kathleen Eva Brown, who passed away on. When did she die?
She died on 3/6/2016, my lord,
At
in Australia.
Australia. The petitioner has placed on record the last will and testament of Kathleen Eva Brown, which is attested by who are the attesting witnesses?
Rosemary Croach and Marjorie, my lord.
Attested by one Rosemary Crouch and M. Andaganti,
Marjorie Canigut.
both residents of Australia. An affidavit of one of the attesting witnesses, Rosemary Crouch, has also been filed, in which she has stated that she witnessed the signature of Kathleen Eva Brown on the will
29/7/2020.
29/7/2002. And about her attestation to the said signature of Kathleen Eva Brown on the will. The petition indicates that Kathleen Eva Brown had left free and one immovable property bearing new municipal number 25, situated at North Road, Thomastown, Bangalore. State be worth about 50 lakhs. Citation was ordered to be published
Vijay, Karnataka.
in Vijay Karnataka newspaper, and the same was published
And Hindu, my lord.
on
Vijay, Karnataka and Hindu.
Vijay Karnataka and the Hindu. And the same were published on 8th of April 2021. There has been no claim forthcoming on 8th of April and 17th of April, respectively. There's no claim put forth by anybody. You're not very sure about the letter of submission at
No,
Australia?
that is only with regarding to the estate over there in Australia.
You've been granted one or not?
No, I'm not aware, my lord, whether but this bill is only with respect to the Indian estate.
In the light of the affidavit filed with the attesting witness, and also taking into consideration the fact that the petitioner is the son of the deceased Kathleen Eva Brown and is entitled for grant of letters of administration.
Yeah, I have even examined the PA holder in the petition, my lord.
It would be appropriate to grant the petitioner letters of administration as sought for
With the will annexed, my lord.
with the annexed will dated 29th of July, right?
Yes,
July
sir.
2002.
Two.
So the petitioner shall be required to comply with the requirement of the provisions related to inventory and account as provided under the Act and rules.
A request, my lord, may the dispensing of bonds for surety may be dispensed.
Why?
Because for letters of administration, the request is made by the office for bonds with surety. The petitioner will file a bond, but without surety, I would
Why?
request.
Why? Let there be a surety. What is wrong?
One surety may be permitted, my lord.
Number 67. Ego.
In this petition, my lord, I have sought for grant of probate.
What is
to
the
the
officer objection? What is the officer objection?
So these have been cleared. It's listed for final hearing today, my lord.
What is the officer objection?
The office objection was issue of notice to the deputy commissioner, which was dispensed with.
Filing of witness affidavit is overruled at the time. 5924. What is the order dated 5924? It's probate rules. Who's the applicant?
The petitioner is a gentleman by name T.G. Ramesh, my lord, and he has sought for grant of probate. May I point out to a certain provision, my lord, here, section 272 of the Succession Act.
Who is related to the testator?
He's a business associate. They had agreed to buy this property from, which was the asset of the deceased. And they were in that connection, they were friendly with each other, and that is how he came to be appointed the executor of this will.
He has no children.
She had an adopted child. He's been made a party also, and in the proceedings, he's an adopted child, my lord. He is not a natural born child. He was living with and I have indicated in the petition that he is, an adopted child of the deceased. He is the only person. Other than them, there's nobody else, my lord.
She's no brothers, sisters, nobody?
No. She's an 80-year-old woman, my lord. She had no children at all. This boy was just an adopted child. I pleaded that in the petition too, my lord.
Was notice sent to this Gopal Krishna?
Pardon, my lord?
Notice sent to Gopal Krishna, the adopted son?
I have taken the steps to be issued to the, as directed by the court, I have taken notice to the deemed relations in the matter, my lord. I have paid the process fee in the court and, and I have taken public notice also.
Gopal Krishna. Gopal
I am required to only specify his, I have shown the family tree there also, my lord, in the petition. There's a spot citation is also ordered at the residence, man.
I would rather want him to be notified personally.
I have no objections if your lordship considers it necessary to take out notice to him. I'm happy to do it, my lord.
Notice that in the petition, while seeking for grant of probate, it is stated that the testator had adopted a son called Gopal Krishna, who is said to be a resident of Sargur town in Ekadadevanakkote Taluk. In my view, it would be appropriate to issue notice to Gopal Krishna about the filing of this petition and seek his response. Consequently, issue notice to Gopal Krishna, who is stated to be residing at door number 1356, Sri Chaudeshwari Street, 10th Ward, Sargur Town, Ekadadevanakkote Taluk, Mysore District, 571121. Relist. 12th December.
How day?
12th December.
12th December. Very well. I'll take steps tomorrow. Oblige me.
Number 68. Vivekananda. Number 68.
Relist.
Sir, unmute ಮಾಡ್ಕೊಳ್ಳಿ. Sir, Vivek.
I can't hear you. I'll have it next week, Mr. Vivek. I can't hear you. Next week.
Sir, unmute ಮಾಡ್ಕೊಳ್ಳಿ. ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
Mute ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ, ಯಾರು ಬರ್ತಾ ಇಲ್ಲ. Relist. 6.
Number 69. Shri Vilas Chicken Gowda.
Plus, I am appearing for the petitioner in this case. I request for a short accommodation.
2011 Godre, last time time ಕೊಟ್ಟಿದ್ದೆ ನಾನು.
Last time ಕೇಳಿದ್ದೆ. ಅದಕ್ಕೆ your lordship may kindly have it on 5th month. Personally, I will come and attend.
Matter ಏನು?
Regarding the grant of land, my lords, 2 acres have been granted to father. I am for the petitioner.
Grantee purchaser.
Purchaser. Respondent number 5's father was granted with the land, and he sold the land to one person. That person sold again to, so it changed 5 persons' hands. Again, it went back to the original grantee. Then original grantee again, he sold it to me. My lords, when the land was granted to him, it was only.
Resumption ಆಗಿತ್ತಾ?
ಇಲ್ಲ ಇದ್ರ ಕೆಳಗಡೆಗೆ ಡಿಫರೆನ್ಸ್ ಕ್ಲಾಸ್ ಗಳಿಗೆ ಗ್ರಾಂಟ್ ಆಗಿತ್ತು SC ST ಇದ್ರೊಳಗೆ.
You said it was sold to you again by the grantee.
ಹೌದು.
ಯಾವಾಗ ಮಾಡಿದ್ದು?
Grantee, not grantee, the first purchaser of the grantee, sorry. First purchaser of the grantee sold it to me. And when it was sold to me, it was 3 acres 22 guntals. And what was granted to.
That was the first sale.
ಹೌದು. First sale.
There are 2 grants. One is in.
Ready ಆದಂಗೆ
It took over the grant, my lords, first sale,
Second grant 1960. 62. Second grant.
2005, my lord.
ಆಯ್ತು, next Friday ಹಾಕೊಳ್ತೀನಿ, ರೆಡಿ ಆಗಿ ಬನ್ನಿ, ಲಾಸ್ಟ್ ಚಾನ್ಸ್. Please don't ask for time again.
There are two strips are the same. One strip, there is no dispute. It reached finality.
He's
It
not-
reached finality.
He's not ready, so I can't.
Please.
Sixth. Silver 70. Gautam Dev.
My lord,
May I request for fifth, my lords?
my lord, this is
Five, 12, my lords, sorry.
All right.
my
Fight.
lord. My lord, in this case, my lord, it's about the dispute is I'm appearing for the grantee, my lord. The order is in our favor only, but only dispute is regarding in whose, because there is a will in my favor. The son of the original granting, grandson of the original grantee is having a will in his favor. The request of the petitioner before this honorable court is that the mutation and the direction for restoration should be in favor of him. That is only, but my lord, one submission fairly I have to make, my lord, but I don't know, this is an objection wakalat which I got, my lord. The respondent who had filed the appeal before the commissioner, assistant commissioner, it's not made party to this proceedings, my lord. Now
He has not challenged the order of.
he didn't challenge, my lord. We filed appeal.
ಇವೆಲ್ಲ ಯಾರಿಗೆ?
We are all family members.
All same.
We all belong to the same family members. But ultimately, there was a sale made in favor of a third party. That now has been annulled by the assistant commissioner by virtue of the order passed under section 4 of the PTCL Act. Now, the list, if I could just sum it up, is should it belong to the original grantee himself, or should it belong to the persons who are also beneficiaries, under a partition which is already affected?
Because the will, date of the will.
Will is not something in question. Will is not.
He's saying that he has a will in his favor by the grantee.
For that, there is a civil suit pending. It is in form
Yes,
of a second appeal filed by them.
We lost the suit also, my lord.
There is a second appeal pending.
And we have filed
So
appeal.
subject to
What
that,
happened in second appeal?
It's pending before this honorable court. My lord,
Then I will say it be subject to the.
subject
that's all. I think we can resolve this entire dispute.
that's all.
ಇವೆಲ್ಲ ಅದೇ ತಾನೆ?
Well, I know.
This petition is filed by the legatee of the grantee, contending that the order of resumption which has been passed by the authorities should inure only to his benefit and not to the legal heirs of the grantee. Next paragraph. It is not in dispute that the petitioner had filed a suit in OS.
My lord, my lord,
That's OS number.
3 of 2007.
Post 3 of 2007, basing his claim on the will, and this suit has been dismissed and also confirmed in appeal, correct?
Yes.
It is also stated that a second appeal in RSA
It is RSA 1040 of 2018.
is pending consideration before this court. In the light of the above, it is clear that the right of the legatee, that is the petitioner under the will, has not been established, and therefore he cannot seek for direction that the order of resumption should inure to his exclusive benefit. Stop. The petition is therefore disposed of, holding that the order of resumption shall inure to the legal heirs of the grantee, but they shall be subject to the ultimate result of RSA number
1040 of 18.
My lord, one thing what happened, my lord, now in RSA, in original suit and all, before those courts, the observation made in this order that the will is not valid has been taken into consideration, my lord. Num OS ಅಲ್ಲಿ observations ಏನ್ ಮಾಡಿ
RSA independent ಆಗಿ ಮಾಡ್ತಾರೆ.
independent, that may be observed, my lord.
It is subject to the ultimate result
but
in RSA.
This observation by the official, my
It
lord.
is to state that any I cannot pass an order.
Coordinate bench.
RSA ನಾನು
ಅದೇ RSA ಬೇಡ, ಇವ್ರು ಅಬ್ಸರ್ವ್ ಮಾಡಿರೋದು will not civil suit ಗೆ.
I am just like telling the subordinate bench that don't look at all that. ಅವ್ರು ಮಾಡ್ತಾರೆ ಬಿಡಿ ಅವ್ರು.
Oblige.
My lord, an humble submission, my lord.
Yes.
My lord, serial number 64, my lord. I could not join immediately, plus 64, my lord.
Next Friday. Next Friday.
My lord, interim order, ma'am.
ಮಾಡ್ತಾರೆ.
Extended.
Small submission, my lord. Serial
Interim
number
order.
74.
Extend ಮಾಡ್ತಾರೆ.
Please, sir.
Serial number 74. It may be taken up next week, my lords. There is some inconvenience to senior council, my lord.
ಯಾವ ವರ್ಷದ ಅದು?
20.
Budgeted thing are more than 2 times.
Lords.
You
Today
argue,
there
let
is some
us.
personal inconvenience, my lords. Kindly, my lord.
You argue, you are here.
Lords. I'm new to this office, my lord. Kindly.
71 Sir, 71.
71 ಬೆಳಗ್ಗೆನೇ ಆಯ್ತು.
ಬೆಳಗ್ಗೆನೇ ಡೇಟ್ ಕೊಟ್ಟರು.
Notice.
Yeah,
EML notice. It was January. 6.
73.
ಇಲ್ಲ ಇದು.
Court officer. Court officer.
Okay.
Court officer?
Court officer?
Court officer? Court officer?
Court officer.
Court officer?
ಹೇಳಿ ಮೇಡಮ್.
ಗಿರಿಜಾ ಹಿರೇಮಠ HCGP ಧಾರವಾಡ ಸರ್.
Madam.
ಆಯ್ತು
Madam, serial number 16.
Forward bench matters. For order serial number 1, 3. Hiranagowda ke complaint.
Please, my lords. For petitioners, there is office objection regarding the non-filing of the objection to the application filed under section 457 of the CRTC. The office objection may be dispensed and the notice may be issued, my lords. Application for the application under 457 is being rejected, my lords, by the trial court. Application for defreezing the amount is being rejected by the trial court. Agreed by that, the order is being challenged before this court.
For the present, these people will take notice. Who appeared for the complainant there in that case?
Complainant Prashant Hospani, my lords, is the counsel for appearing for the bank, my lords.
For R2. List.
Number 2, 3. Chetan Mulnodi.
My lords, I appear for petitioner. My lords, through oversight, my lords, I have not served the copy upon HCGP. In fact, it is covered by judgment of this honorable court in criminal petition 100515 of 2024, wherein, my lords, insofar as accused number 2 was quashed. Present petition by accused number 9 and 10, my lords.
To CGP to take notice for respondent 1 and 2. What is the office objection?
My lords, I have to serve the copy upon the HCGP. My lords.
Subjects be complied with by then.
Date.
Number 3, VM Shilwan.
Please, Lordship, for the petitioner, Lordship. The petitioner here are the mother-in-law and sister-in-law, Lordship. The offense, Lordship, 323, 341, 448, 504, 506, Lordship. In fact, Lordship, the daughter, Lordship, she had been, minor daughter, she had been harassed by the second respondent. For that, to that effect, Lordship, 2 more complaints have been filed by the petition number 1, Lordship. The case and counter cases, Lordship. 164 statement of minor girl is there also, Lordship.
CGP to take notice for respondents. Respond number 1. Shows to R2.
May I seek a stay, Lordship, because Lordship, they are the old age lady, Lordship. Lordship, for the appearance, Lordship. I filed the order sheet also, document number 3, Lordship.
I'll hear the HCGP next week. Relist.
Yes.
Number 4, 3. Pawan Dodatti.
Please, my lords, I appear for the petitioners, my lords.
Yes.
This petition is by accused number 1 and 2, my lords. Criminal proceedings are brought against the accused number 1 and 2, my lords, without arraying the society as a party, my lords. They are the president and secretary. Complaint copy is at Annex A, my lords, page 8.
Yes.
Lords, in their individual capacity, my lords, they are arrayed as accused without arraying the society, which is an legal entity, my lords.
Did I pass any order earlier?
Please, my lords, in respect of other members, my lords, your lordships have passed.
In respect of?
Other accused number 3 to 7, lords, your lordships have passed the proceedings.
Who appears for accused number 3 in that case?
Lords, me only, lords. I have appeared.
No. So for the,
In that respondent, my lords,
the respondent.
Jagdish Patil, my lords, had appeared.
For the respondent here appear adra.
Jagdish Patil, my lords, had appeared.
Jagdish Patil take notice for respondent. Relist.
Bill number 5, Sri H.M. Darigon.
For the petitioner,
Eli Darigon.
but the office objection is one copy not sold to the government, Malan, by words of not sold, Malan. And also, Malan, the accused number 8 also approached this honorable court. This honorable court caused the entire proceedings. In section number 102499 of 2023.
SAGP to take notice. Submission complete with release.
Number 6. Mahantesh Siramat. Mahantesh Siramat.
SAGP to accept notice for respondent. Respondent release. Submission complete with the meeting.
Number 7. Avinash Blankar.
Same.
Number 8. Number 8.
SAGP to take notice.
For admission, number 9.
But can I make one submission? Serial number 7 and 8, there was some glitch in the internet.
Take out notice on the ground plater.
One more submission would be, my lordship has quashed the proceedings against accused number 1 and 2. The learned magistrate, by filing an application by the prosecution under 390, he has made the company as a party. My lordship, I have mentioned the order of this honorable court at para 27, wherein in criminal petition number 100398 of 2024, accused number 1 and 2, wherein they are retailers and the suppliers of fertilizer products. Company was not made as a party, so the petition was allowed.
You give a copy of the petition to her. I hear it next week.
Much
Please.
For admission, seal number 9.
8 also thing.
Please.
Yes.
Lord.
Seal number 9.
9.
Lord, Lord, I appeal from behalf of Mahantesh Patil. May I seek more next week?
Release.
Number 10. Anand Kumar.
Anand Kumar.
Anand Kumar.
Released.
Seal number 11. Sri J.M. Anil Kumar.
Released.
Seal number 12. Sri Jagdish Patil.
My lord, in this matter, I appeal for petitioner, my lords.
Yes.
Petitioner is accused number 5, my lords, who is the brother-in-law. My lords, the offense is under section 498A, 323, 504, 506, read with 149 of IPC, and under section 3 and 4 of the Dowry Prohibition Act.
You take notice for R1.
My lord, already stay has been granted.
Madam, nodidira?
Please, your lordship.
Petition is accused number?
Petitioner is accused number
Case number 5, your lordship.
5, my lords.
Brother-in-law, na? You muted yourself.
Unmute. Sajid, unmute.
Sorry, ma'am. My lord, accused.
The brother-in-law of the complainant. So as against the
11 of, page number 11 of the complaint, your lordship.
iವ್ರ ಮೇಲೆ ಇದೆಯಾ?
Please, your lordship. Anil, page number 11 of the complaint, your lordship.
Yes.
ಶಶಿಕಲಾ ತಂಬಗಿ ಮತ್ತು ಅವರ ಮಗಳು ಅರುಣ ಮತ್ತು ಅವರ ದೊಡ್ಡ ಮಗ ಅನಿಲ್ ಇವರು ಯಾವಾಗಲೂ ನನಗೆ ಚುಚ್ಚಿ ಮಾತನಾಡ್ತಿದ್ದರು.
ಏನ್ ಮಾಡಿದೆ? The father-in-law, mother-in-law and sister-in-law would be arraigned as accused number 234. This court in criminal petition 103312/2023 had quashed the proceedings as against them by an order dated 29 January 2024. This court had taken note of the fact that the allegations in the complaint were essentially against the husband who had been arraigned as an accused number 1, and the allegations against the other accused were only omnibus allegations. In my view, in the light of the judgment already rendered in respect of accused number 2 to 4, the proceedings as against the petitioner shall also be should also stand quashed.
Grateful.
Bill number 13, T. Anuma Reddy.
Minutes, back for petitioner minutes. Minutes, so far as minutes, may I take minutes to page number 16? In so far as A2 is concerned, minutes, my lords had already quashed the proceedings minutes. Minutes, the case of prosecution is that minutes, the complainant here in minutes, page 16 minutes, the para number 6 minutes, before going to facts, may I take minutes to para 6 minutes? Page 16, para 6 minutes.
Santosh, are you ready?
Yes, I'm ready. I also filed my statement of opposition.
Who are you? You are the?
Minutes, the present petitioner is accused number 3 minutes. A2 is already quashed. Accused number 3 is a FDA. Minutes, may I take minutes to page 16, para 6 minutes?
Accused number 3 is before your lordships.
In a Ridhi or Male, same principle?
Yes. We have material against him also, my lords.
What is the material?
My lords, in the complaint itself, my lords, the accused number 1 has placed a demand on his behalf and also on the behalf of the present petitioner for a sum of rupees 20,000 for getting done the work, my lords.
Who was the petitioner?
Accused number 1. Petition number is, my lords, the accused number 3. That is, he is a case worker.
FDA means.
He is a case worker.
FDA. Yes. He is a case worker. And in order to issue CC, my lords, he is also one of the person who is lords, relevant for lords, signing of certain documents in respect of the work pending.
Yes.
Insofar as this case is concerned, he is definitely, my lords, having a serious role. And apart from this, he is already, my lords, accused in 3 similar crimes, which are, my lords, registered against him. Wherein in one particular case, my lords, against him only the trap was conducted and the trap was successful. And he is, my lords, the employee of RTO office. In order to, my lords, get done the work of the complainant.
Where is he? What is the allegation against him in the? What is the allegation against him in the complaint?
Please, may I take my lords?
Para 13, page 13 may kindly be returned. Page 13, the paragraph, relevant paragraph. Adarante, hope you lordship got it. ಅದರಂತೆ ನಾನು ಚಂದ್ರಕಾಂತ್ ಗುಡ್ಮಣಿ ರವರ ಹತ್ತಿರ ಹೋಗಿ ಮಾತನಾಡಿದಾಗ, ನೀವು ಸಿಸಿಗೆ ಎಷ್ಟು ಕೊಡ್ತಿದ್ರಿ ಎಂದು ನನಗೆ ಕೇಳಿ ನಂತರ ತಮ್ಮ ಮುಂದೆ ಇದ್ದ ಕ್ಯಾಲ್ಕುಲೇಟರ್ ನಲ್ಲಿ 20,000 ಟೈಪ್ ಮಾಡಿ 20 ಮಾಡು ಎಂದು ಹೇಳಿರುತ್ತಾರೆ. ಅದಕ್ಕೆ ನಾನು 20,000 ಸರ್ ತುಂಬಾ ಜಾಸ್ತಿ ಆಗಿರುತ್ತದೆ ಎಂದು ಹೇಳಿದಾಗ, ಇಲ್ಲಿ ಇದರಲ್ಲಿ ನನಗೆ RTO ರವರಿಗೆ ಮತ್ತು ಕೇಸ್ ವರ್ಕರ್ ರವರಿಗೆ ಇರುತ್ತದೆ, ಇದೇನು ಜಾಸ್ತಿ ಆಗಿರುವುದಿಲ್ಲ ಎಂದು 20,000 ರೂಪಾಯಿ ಲಂಚದ ಹಣಕ್ಕೆ ಬೇಡಿಕೆ ಇಟ್ಟಿರುತ್ತಾರೆ. ಈ ಮಾತುಕತೆಯನ್ನು ನಾನು ನನ್ನ ಸ್ಯಾಮ್ಸಂಗ್ ಸ್ಮಾರ್ಟ್ ಮೊಬೈಲ್ ಫೋನ್ ನಲ್ಲಿ ರೆಕಾರ್ಡ್ ಮಾಡಿಕೊಂಡಿರುತ್ತೇನೆ. Accused number 1 on the behalf of RTO as well as a case worker.
But how can you, if somebody asks for money on my behalf, can you say that I am involved? Is there any other material against this gentleman?
Milos, why I am trying to press upon this petition is, Milos, admittedly, Milos, the present petitioner is working under the accused number 1. And he is not only in this case, in the similar cases of 3 cases which are pending against him, he is already, Milos, accused. And in 2 trap cases, it is only against him, Milos, the trap was conducted and trap is successful and it is pending investigation before us. And in the said trap proceedings, when his house was also, Milos, searched, in the house, Milos, again, Milos, he has stored illicit liquor
and against which, my lords, an excise case has also been registered against this petitioner. My lords, he is in the habit of committing such crimes. I won't say that he is an habitual offender, but still the matters are pending before him.
ಬರೀ
They
illicit
are
liquor
pending
ಅಷ್ಟೇನಾ?
investigation. ಅಲ್ಲ, ಲಿಕರ್ ಜೊತೆಗೆ ಟ್ರ್ಯಾಪ್ ಆದಂತ ಅಮೌಂಟ್ ಕೂಡ ನಾವು ಸೀಸ್ ಮಾಡಿದ್ವಿ on against. In that case, my lord, that is crime number. Just pass on. Crime number
ಏನ್ ಇದ್ಬಿಟ್ಟು 3 ಕೇಸ್
8/20.
ಇದೆಯನ್ರಿ ನಿಮ್ಮೆಲ್ಲ?
ಮಿಲಾಟ್ಸ್ ಇನ್ ಕ್ರೈಮ್ ನಂಬರ್
ಇದೆ.
9 ಇಲ್ಲ, ಕ್ರೈಮ್ ನಂಬರ್ 9 ದಲ್ಲಿ ಬಿ ರಿಪೋರ್ಟ್ ಆಗಿದೆ. ಕ್ರೈಮ್ ನಂಬರ್ 8 ದಲ್ಲಿ ಮಿಲಾಟ್ಸ್ ಅದು ಕ್ರೈಮ್ ನಂಬರ್ 8 ಫೈಲ್ ಮಾಡುತ್ತನಾಗ ದೇ ಹ್ಯಾಡ್ ಫೈಂಡ್ ಮಿಲಾಟ್ಸ್ ದಿಸ್ ಇಲಿಸಿಟ್ ಲಿಕರ್ ಇನ್ ಮೈ ಹೌಸ್. ಅದಕ್ಕೆ ಮಿಲಾಟ್ಸ್ ದೇ ಆರ್ ರಿಜಿಸ್ಟರ್ಡ್ ಮಿಲಾಟ್ಸ್ ಕ್ರೈಮ್ ನಂಬರ್ 5. In crime number 9 milots, the very local that file milots B report which has attended finality.
Is it true, Santosh, that B reports are filed?
Crime
In
number
a crime
9,
number
9 ದಲ್ಲಿ
in crime number 9/2019, my lords, he is facing the disciplinary action, my lords, and that is pending inquiry still.
ಇಲ್ಲ ಅದು B
So far as crime number 9.
Crime number 9 is for what?
My lords, it is of similar, my lords, trap case, my lords. It is also a trap case.
ಇಲ್ಲ ಮಿಲಾಟ್ಸ್
And
ಅದರಲ್ಲಿ
wherein, my lords, the direct allegation was not against this petitioner in that case. But however, my lords, he is attending, my lords, the disciplinary inquiry every day till now. But so far as crime number 8/24 is concerned,
What is the other crime?
crime number 8/24, my lords, that is a case wherein it was directly hit for this petitioner because he is the accused who has demanded, my lords, 2,000 rupees for arranging a driving retest of the complainant.
No.
And after giving that amount,
in this there is no B report?
no,
If this
it
is
is
the-
pending investigation.
What's
It
crime
is pending
number
investigation.
What is the third case?
excise.
The third case is the excise one, which is, my lords,
Crime number?
the collateral case of 8/24. That is 5/24. Excise case is 5/24. That is Hospete PS crime number 5/24.
ಯಾವ್ದ್ರಲ್ಲಿದೆ B report?
Please milots, milots crime number 9/2019 ದಲ್ಲಿ B report ಆಗಿದೆ milots.
Yes.
Milots,
Eight
that, milots, so far as crime number 8 is concerned, in this case, milots, interestingly, again on my behalf, milots, some other person has taken the accused milots bribe amount, even as per case of prosecution.
ಎಲ್ಲರೂ ನಿಮ್ಮ ಹೆಸರು ಹೇಳ್ತಿದ್ರೆ ನಿಮ್ಮ ಮೇಲೇನೂ ಇರ್ಬೇಕಲ್ವಾ?
ಅಲ್ಲ, ಇದಕ್ಕೆ milots, what happens is milots, I obtained milots stay on 2/8/2024 before KAT milots. Milots, I was transferred milots, I got my transfer order stayed. Thereafter milots, all this case is registered. It is milots at the behest of milots, I should not submit so, as milots they don't want me to work in that office. Admittedly, in crime number 9/2019, the same local has filed B report. Idu 8 ದಲ್ಲಿ ಇದರಲ್ಲಿ ಕೂಡ milots I am not involved. And milots ಈ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ದಲ್ಲಿ ಇದು ನನ್ನ ಮನೆ ಸರ್ಚ್ ಮಾಡಿದಾಗ they say that I was found with milots some legal.
Crime number ಎಷ್ಟು?
The present
7/23.
this is milots crime number 7 milots 7 of milots
Yes.
2020.
So 7/23 there's a trap case. 8/24 next year also
Yes.
there's a trap case.
ಹೌದು.
Yes.
When did you get a stay of your transfer according to you?
milots 2/8/2024 milots.
No, but 23 ಅಲ್ಲಿ ಒಂದ್ಸಲ ಆಗಿದ್ರೆ ಹುಷಾರಾಗಿರ್ಬೇಕಿತ್ತಾನೆ ನೀವು. ಈಗ ಅದೇ ಕೆಲಸ ಮಾಡ್ತೀರಿ ನೀವು.
ಇಲ್ಲ milots may kindly see my
Santosh, who was A1 in 8/24?
Please, in 8/24, milots, it is alone. He alone is a petitioner there. He is alone the accused.
para number 7 is my lord.
He is accused number 1.
No, in 8/24 direct demand.
Yes, he has demanded, but however, the amount is been asked to give it to his assistant, and the amount is given to his assistant. Trap is successful. He is the one who has demanded, and we have call records of that particular case also.
ಆಗ್ಲಿ ಬಿಡಿ, ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಲಿ ಬಿಡಿ ಹಂಗಾರೆ.
milots ಅದರಲ್ಲಿ milots may milots so far as this case is concerned milots may kindly see admittedly milots in crime number 9/2019 milots there is a B report. So far as milots my date of transfer is concerned, that was 2/6/1993
No,
milots.
crime number 8/24 is pending.
Yes, milots, pending investigation.
milots so far as
It's
this
not a lone case. Consistent record ಇದೆ ನಿಮ್ಗೆ.
ಇಲ್ಲ milots may kindly see milots now the only case which is pending is crime number 8 milots. So far as the
That's why I said you were facing a case in 7/23 and you were not smart. You persisted in the same thing.
ಇಲ್ಲ milots may kindly see here for a moment milots for a
ಬಿಡಿ,
moment
ಒಂದ್ ಕೇಸ್ ಇದ್ರೆ ಇನ್ನೊಂದ್ ಕೇಸ್ ಇರ್ಲಿ ಬಿಡಿ, ಎರಡ್ ಕೇಸ್ ಅಂತೆ.
milots ಇದರಲ್ಲಿ milots their case is milots this amount is demanded milots for clearance of certificate. milots I am the person who as per the case of prosecution page number 18 ನಂದಿರೋದು ಬರೀ issuance of DL. ಆ DL ಅವ್ರ ಕೈಯಲ್ಲಿ ಕೊಡೋದು ಅಷ್ಟೇ. page number 18 milots is my work nature.
ಇನ್ನೊಂದ್ B report ಹಾಕ್ಸಿ ಅಷ್ಟೇ.
ಇಲ್ಲ milots may kindly see milots similarly placed para 13 ದಲ್ಲಿನೇ milots if the court permits ನನಗೆ RTO ಗೆ ಮತ್ತು ಕೇಸ್ ವರ್ಕರ್ಗೆ This RTO is accused number 2, my lords, wherein my lords are pleased to quash, my lords, so far as RTO is concerned. Here, my lords, the case worker FDA, my lords, my work nature, my lords, as per my lords, the case of at page 18, I am concerned only with issuance of license. Even there is no pendency of work with me. My department itself is different, my lords. This was what was observed, my lords, on the last date of hearing. My department, my lords,
The investigation agli bide. There are 2 cases, there is some kind of doubt about your character.
Illa, my lords, may kindly appreciate all these things happen, my lords, only after I obtaining an interim order of stay before KAT, my lords.
Bide, ಅಲ್ಲಿ ಯಾಕೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರೆ ನಿಮ್ಮಲ್ಲಿ ಕಂಡಿಟ್ಟಿದಾರಲ್ಲ ಸುಮ್ಮನೆ don't waste your time and energy there.
But not pendency of this case, this was what was appreciated notes on the earlier occasion.
No,
This
even if I quash this, is one more case pending, you can't escape that case.
ಇಲ್ಲ ಅದರಲ್ಲಿ ಕೂಡ
Certainly,
amount is required minutes from the assistant minutes, assistant RTO, not me minutes. ಅಲ್ಲಿ ಕೂಡ para 7 ದಲ್ಲಿ if my lord peruses as per the objections, it was minutes received minutes by the other accused.
I'm not inclined, I dismiss it.
Minutes, may minutes may kindly say para number minutes, page 13 minutes may I take note the first para itself. If the court bears me for some time, minutes ಅಲ್ಲಿ line number 3 ದಲ್ಲಿ ಇದರಲ್ಲಿ ನನಗೆ RTO ಮತ್ತು ಕೇಸ್ ವರ್ಕರ್ ಇವರಿಗೆ. So minutes,
You are the case worker. You are the
Not-
case worker.
even.
Oh, minutes, minutes, only see page number 18 minutes. I am not concerned with the department at all. My minutes work is only to issue DL. The demand is minutes for clearance in sale minutes department. I am not concerned with sale department. The case
But
of
that, you can establish that in the course of investigation. Why should I stay the investigation?
My notes may kindly see notes. The facts of the case are that notes the complainant notes approached the section number 1 for getting not sale certificate, clearance certificate, as he had sold his vehicle. I am not at all concerned notes with clearance certificate minutes. This clearance
There is no-
is not at all my duty. And minutes kindly see notes even notes the audio recording minutes. Let my friend minutes produce the minutes. Minutes otherly kuda non conversation.
I can't go into the merits of the case, isn't it?
Minutes I am
They have not filed, they have not filed application for stay only in this case. It's a mere petition. They have not filed an application for stay in this.
Because minutes, as far as minutes other accusers, the allegations were one and the same. Minutes had minutes only filed minutes had not minutes filed any stay application. Minutes may kindly see minutes this petition was in fact pending since 1908. This was heard minutes after considering minutes this particular allegation. Even minutes on the earlier occasion I was informed that minutes had made up a mind that minutes as I am minutes similarly placed with that of RTO. The allegation against RTO.
You can't be in the same status as an RTO.
ಇಲ್ಲ ಹಂಗಂತ ಇಲ್ಲ minutes I am not at all a person with whom minutes the work is pending.
Okay. Anything else?
I am not only minutes. This is my submission.
The petitioner is the third accused in crime registered for offences under section 7 small a subclause a and capital A of the PC Act. So it is the case of the petitioner that in respect of accused number 1, on whose behalf an alleged demand was made, this court has quashed the proceedings in criminal petition 103428/2023. And since the complaint also indicates that demand was made on behalf of the petitioner herein,
accused number 1 minutes.
The case request we quashed. Next. The criminal petition 103428/2023 was filed by the RTO, who had been arraigned as accused number 1. Since it was stated that a demand was made on behalf of the RTO and the case worker. Your A3 na A1 na?
A3.
103248 ಅಲ್ಲಿ.
A2 milords. A2 milords.
ನಂಗೆ ತಪ್ಪು A2 ಇರಬೇಕು. RTO A2. In the criminal petition 103428/2023, the process by RTO was arraigned as accused number 2. This court came to the conclusion that a demand made on behalf of the RTO by accused number 1 would not attract the provisions of section 7 small a and capital A of the PC Act, and accordingly quashed the proceedings. However, it is noticed that the present petitioner, that is accused number 3, was the case worker, and therefore the demand made on his behalf would have to be investigated. And therefore the view that this is not a fit case to entertain under section 482, the petition is therefore dismissed.
Lords,
Great.
after filing
Great.
of charge sheet, Lords, liberty may be reserved to approach this question.
It's needless to state that the petitioner can challenge the charge sheet, if any, that is laid against him.
Seal number 14.
Great.
Please.
14.
The petitioner is appearing from my.
Yen madam?
My lords, I am representing the petitioner number 126, my lords,
Yes.
who happened to be accused number 328 in crime number 23 of 2021, my lords.
Yes.
It is filed before Women Police Station, Ballari, my lords, for the offences punishable under 498A, 498A, 323, 504, 506, read with 34 of IPC, and
Who are you? The first petitioner.
we are mother-in-law, my lords, accused number 3. Respondent number 2 is the wife of accused number 1, my lords. The petitioner herein are accused number 3, my lord, who happens to be mother-in-law. Petition number 2 is accused number 4, brother-in-law, my lords. And 5 is brother-in-law's wife, my lords. And 4 to 6 petitioners are accused number 6 to 8. They are sisters of accused number 1, my lords, who are staying in a matrimonial home, my lord.
The petitioners are accused number 3 to 8. They are agreed by the resolution of a criminal case against them for offences under section 498A, 504, 323, 506, 34, read with section 3 and 4 of the DP Act. Charge sheet hakidara?
Yes, ma'am.
Pursuant to the investigation, a charge sheet is also being laid against them. It is the contention of the petitioners that the allegations against them are only general allegations and there are no specific instances of dowry harassment as required in law. In my view, on the perusal of the complaint, it is clear that the averments made against the petitioners are general allegations and does not deserve a prosecution for offense under section 498A. It is also noticed that the second respondent has arrayed her sisters-in-law who are residents who are residing with their respective families elsewhere. So, therefore, the view that the proceedings as against the present petitioners are required to be quashed and they are accordingly quashed.
Madam, ನಿಮ್ಮ ಹೆಸರೇನು madam?
Reshma Madivalar.
Seal number 15. Bashwaraj Matapati.
Lords, I am for the petitioners, your lordship. The offences are punishable under section 420, 465, 468, 471 of IPC, my lord. Lord, the case of the prosecution is, your lordship, the complaint came to be filed on 20th December 2022, my lord. And the alleged incident was happened on 16th January 2016, my lord. The complaint is filed after lapse of almost more than 6 years, your lordship. The case of the prosecution is, my lord.
Madam?
First time, your lordship, I'll take notice. And respondent number 2 is notice has to go, your lordship.
For R1, issue notice to R2, na?
Only sole one respond, my lord, served the copy to the government. May I seek for the interim order, your lordship?
No,
my lord, kindly, my lord, they are on the regularly going to the attending the proceedings, my lord. They are only for
case haki.
My lord, 2022, my lord.
You are coming
now
now.
They are out on the bail, your lordship. Kindly, there is urgency, my lord.
I fixed a date. Get them served on that particular date.
Seal number 16. Anand B. Bhagyawadi.
Please, Lord. Lord, in this case, Lord, complaint has expired, Lord. It is mentioned in the charge sheet. Lord, page number 88, my lord, already passed the proceedings against accused number 2, 3, 4, 5, Lord.
Madam.
Please, your lordship. I'll take notice, your lordship. All these 4 matters, your lordship, first time.
Lord, it is covered by judgment, Lord. In the complaint expired. There is no, Lord, proceedings against, Lord. These accused number 1 and 2. Accused number 3 to 5 already, my lord, page number 88.
In complaint, ಏನು offense ಇದ್ರಲ್ಲಿ?
My lord, offense is not.
Madam, ಇದು ಕಂಪ್ಲೇಂಟ್ ತೀರೋದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು ಇದಕ್ಕೆ?
Now, ಎಲ್ಲಾರ್ application is to be filed.
There is no allegation against my in the complaint.
Today I have filed a memo for withdrawal. I may be permitted to withdraw this petition at liberty to approach the proper forum.
ನೋಡ್ತೀರಾ ಇಲ್ಲ ಆರ್ಡರ್ ಮಾಡ್ಲಾ?
Order ಮಾಡ್ಬಿಡಿ because complainant is no.
The petitioners are accused number 1 and 2 and agreed with the registration of criminal complaint.
Please, I paid today.
Criminal case registered against them for offense under section 365, 323, 324, 504 and 506 of the Act. So, learned counsel for the petitioner submits that a charge sheet is also laid against them and the contents that the complainant is no more and therefore the proceedings are required to be quashed. It is not in dispute that the complainant who had filed the case against the petitioners is no more and consequently the petitioners would be entitled for quashing of the proceedings. Consequently, the proceedings are quashed.
Still number 17, Shri Prashant Osmani.
My lords, I appear for the petitioner in this case, my lords. The offense, my lords, is 304A, wherein, my lords, the deceased, while, my lords, he was changing the roof of the KSRTC depot in Sirsi, my lords, he fell down and, my lords, he died. The petitioner, my lords, at that relevant period was working as a superintendent, works superintendent in the division of Sirsi. My lords, this complaint was filed and simultaneously, my lords, a prosecution under the Factories Act for offences punishable under section 92 is also, my lords, initiated. It's matter is over the judgment, my lords. My friend there, my lords, will hand over, my lords, 2 judgments of this honorable court. Along with the memo, my lords, I have filed the judgment where it says that
We'll ask her wait. Madam, nodidira?
No, Your Lordship, this is a
ICGB accepts notice for the state. Relist on.
My lords, may I request for an interim order, my lords? Since matter is covered by the judgment.
Next week ಬರ್ಲಿ ಅವ್ರು ನೋಡ್ಲಿ ಅವರು.
please,
Please.
I will go.
Still number 18.
I am for the petitioners, my lord.
Yes.
In this case, my lord, the earlier the petitioner had filed a criminal petition before this honorable court, my lord, and your lordship quashed the order. That is at page number 15, my lord. And relevant para is at page number 17, my lord. Accordingly, criminal postings initiated against the petitioners are closed in the light of the joint memo filed so and so, the statement made in the therein, my lord. Thereafter, the petitioner submitted the same order copy before the court, my lord, at page number 46, my lord.
46.
Please, my lord. Case is advanced married.
Yes.
Case is advanced for the accused for memo along with the order copy of the criminal petition so and so. Same is keep with this file. Thereafter, my lord, the police had filed the charge sheet, my lord. That is at page number 47. The court will has taken cognizance against us, my lord.
Madam.
Your Lordship, after
ನೋಡಿದ್ದೀರಾ?
5.
I had quashed the proceedings, not that it is settled. ಆಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಾಗತ್ತಾ?
Please, Your Lordship, that is wrong. I will get instructions, Your Lordship.
ICGB accepts notice for respondent relist on.
In the meanwhile, stay, my lord.
The stay of all further proceedings.
Please,
For further consideration, still number 19, Shri Vishwanath Bandikar.
Please, my lord, I am for the petitioner in the matter, my lord.
Who issued the charge sheet?
My lord, it is actually the governing council.
Actually, bada.
My lord, I'll say because your lordships kindly see my statement of objection, my lord, the first document.
Let us see the charge sheet. Who has signed it?
No, it is signed by the director. It is signed by the director. Now that is, if you lodge, that is why, my lord, I request my lords may kindly.
No, first let us see the charge sheet, page number.
Yes, my lord. It is at
That's Annexer E, my lord.
Page number.
42, my lord.
Director.
43. ಉಪಾಧ್ಯಕ್ಷರು ಆಯ್ಕೆ ಸಮಿತಿ ಮತ್ತು ನಿರ್ದೇಶಕರು ಧಾರವಾಡ ಮಾನಸಿಕ ಆರೋಗ್ಯ ಮತ್ತು ನರವಿಜ್ಞಾನ ಸಂಸ್ಥೆ ಧಾರವಾಡ.
Those are
Vice President of.
Yes, he is the vice president of the selection committee. Now, my lord, their whole case is that this bylaw, which they are relying, my lord. I'm told, my lord, last date, your lordship has asked me to, my lord, the reply with regarding page number 114, the power. My first submission is that, my lord, this bylaw is no more. We have adopted common bylaw which has been, my lord, prepared by the Bangalore Medical College, and at the instruction of the department, all the colleges in the Karnataka.
When was that adopted?
No, this is 2018, before, my lord, this
2000?
is 2018, my lord. This is adoption is, he himself has produced the resolution. You lordships kindly see page number 55. 55.
Yes.
Your lordships got
Subject?
subject 3, my lord. Subject 3.
Have you produced this bylaw?
Yes.
Or copy ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅವ್ರಿಗೆ ಗೊತ್ತೇ ಇರ್ಲೇಬೇಕು ಅವ್ರಿಗೆ.
ನೋಡಿದ್ರ ಈ ಬೈಲೋ ಅಪ್ಲೈ ಆಗಲ್ವಂತೆ ನೀವು ಹೋದ್ಸಲ ತೋರಿಸಿದ ಬೈಲೋ.
My lord, the respondent may directed to serve the copy on me so that I'll go through that and make submissions on the in the light of new bylaws.
ನಿಮಗೆ ಗೊತ್ತಿರ್ಬೇಕಲ್ವಾ ಬೈಲೋ.
ಅವರೇ ರೆಸಲ್ಯೂಷನ್ ಕಾಪಿನ ಹಚ್ಚಿದ್ದಾರೆ. He is relying in his promotion case.
Why couldn't you have given a copy to him earlier?
I thought that he is also today is Friday, he is also coming here. I'm surprised. But the other contention is that, my lord, whether
Desai has sought lordship's permission that I will be appearing through EC only today, this Friday.
sorry.
May I request to have it on 6th, my lord?
ನಾನು ಅವ್ರಿಗೆ ಕಾಪಿ ಒಂದು ಸರ್ವ್ ಮಾಡ್ತೀನಿ. ನಂದೊಂದು ಸಿನಾಪ್ಸಿಸ್
Statement of objections ಇಲ್ಲ, my lord, ಕೊಟ್ಟಿಲ್ಲ ಅವರು ಅದೊಂದು ಕೊಡಕ್ಕೆ.
6th ಗೆ 6th, my lord, one parted is there. 2:30 is fixed it Dharwad bench.
ಅಲ್ಲ ನಮ್ಮದು ಹೇಳ್ತೀನಿ ನೀವು ಆಮೇಲೆ
You
ಹೇಳ್ಬೇಕು.
lordships permit me to through outlet. Before that, I will file a synopsis.
I'll confirm my results on 6th.
All right.
Yes.
Gurgi bench matters.
Oblige, my lord.
For hearing on I, seal number 1, Shri P.S. Mali Patil.
Not appear for. Lord, I have filed the IA, my lord, seeking for clarification of your lordship's order. The matter, my lord, was disposed of on 17/9/2024.
What is the clarification that you want?
My lords, in paragraph 7, if I may just read, my lords, I'm reading from page number 6 of your lordship's order, the last line of paragraph 7.
1 minute. Let me take out the order.
Yes, my lord. Paragraph 7, the last line, I'll read from there. The impugned order is therefore quashed and the respondents are directed to consider the case of the petitioner for regular employment, just as has been done in other cases and without reference to this period of unauthorized absence. My lords, in paragraph 9, it reads, this process of granting him regular appointment shall be completed within a period of 2 months. My lords, in paragraph 7, it says consider the case. In paragraph 9, it says granting him regular appointment. My lords may clarify which one is applicable. My lords will.
No, and what is the other ground that you have?
My lords?
What is the other ground that you have?
No, my lords, one place it says
You
consider-
refuse to appoint him regularly only on the ground of unauthorized absence. If that goes, what should happen?
My lords, there are other grounds also which they have mentioned.
You can't have fresh grounds. What was the ground that you mentioned earlier?
Unfortunately, the earlier order is unreasonable. It is completely unreasonable. ಏನು ಬರ್ದೇ ಇಲ್ಲ ಅದು. Statement of objections ಅಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ. I must admit, my lords, the earlier order that is passed, which is that Annexure E, of the writ petition on page number 25, it is bereft of reason.
There is no justification for making the application of clarification, since it was made clear that the consideration of the unauthorized absence for denying the petitioner regular appointment was incorrect. And the petitioner and the respondent was directed to consider the case of the petitioner regular appointment without reference to the unauthorized absence. Admittedly, apart from the unauthorized absence, there was no other ground mentioned or raised for denying the petitioner regular appointment. Consequently, IA for clarification is rejected.
Obliged.
Further consideration, seal number 2, the Nitesh Badial.
Preparing for the petitioner's your lordship.
Raganji,
Your lordship, as per your directions, I have informed him personally and through message also, your lordship. I could not see him online.
objections ಹಾಕಿದಾರಲ್ಲ ಅವರು?
No, your lordship.
You were paid the government pay scale?
Yes, your lordship, the society also, your lordship, the contesting parties are the societies. The HK society.
You were for the employee, alva?
I am for the employee.
Your prayer is to either grant you government scale or UGC scale.
Your lordship, in fact, I was appointed in the year 1992 as a lecturer. But in the year 98, from then on, I was appointed as an assistant professor, promoted as an assistant professor. And at the time of the retirement, I retired as a professor, your lordship. And I was discharging the duties of the principal.
Oh, see your prayer. What is your prayer?
Your lordship, I am seeking extension of all the benefits as per the corresponding scale for the year 1992 to 1998. And from 98 to till the date of the superannuation as per the UGC scales, your lordship. At the time of my superannuation, I was working as a principal. I was given the charge of the post of principal.
Or objections hakila ಅವರು?
Akila. In fact, your lordship, on the last 3 occasions also, I have informed him, but they didn't turn up, your lordship. We had filed a IA for early hearing in the month of June, your lordship. He is at the verge of deathbed. He is suffering from a cancer, your lordship.
The petitioner is before this court seeking for issuance of a mandamus. Direct respond number 2 and 3 to extend all terminal and statutory benefits, either of the UGC scale or the corresponding government scale, for the period the petitioner worked as a lecturer from 1992 to 1998, and from 1998 till 2017 when he retired as a professor. The petitioner is also seeking for a direction to be issued to respondents 2 and 3 to extend the salary and other benefits to the corresponding government scale with effect from the date of his initial appointment, along with DA and other allowances till he attained the age of superannuation. The petitioner was appointed as a lecturer on 27/8/1982 under Annexure A. In Annexure A, it was categorically stated that the petitioner would be given salary as per the Government of Karnataka pay scales. Thus, the entitlement of the petitioner for payment of salary as per the Government of Karnataka pay scales cannot be denied. So, however, under annexure D, it is sought to be contended that the petitioner was not qualified as per DCA/MCA norms, and he ought to have had a postgraduate degree in MD, MS, and an MS in general surgery. But the management had not been guided properly by the then principal at the time of the petitioner's appointment. It is also sought to be stated that even for promotion, certain requirements were to be satisfied by the petitioner, and this had been overlooked by the principal at that time. And it is lastly stated that the management had not committed UGC pay scales to any staff members of AME society, but it has been paying Karnataka state government pay scales to those whose services were regularized. It is stated that the petitioner's appointment also indicated that he would be paid government pay scales since 1/4/2003, and the same was paid. And consequently, he would be restored to claim UGC pay scales. As already noticed, in annexure A, the petitioner was appointed on the condition that he would be given salary as per the Government of Karnataka pay scales. However, in annexure D, an argument is sought to be advanced that he is eligible for government pay scales only from 1/4/2003. This is obviously in contradiction of the order of appointment. So, if the petitioner has been appointed on the condition that we entitled to a salary as per the Government of Karnataka pay scales, it is obvious that the petitioner should be paid the Government of Karnataka pay scales from the date of his appointment as a lecturer and his subsequent promotion as a professor. The opponents cannot contend that the petitioner was not qualified to be appointed, or that there was some irregularities which are overlooked after the petitioner had attained the age of superannuation. And therefore, of the view that the petitioner have to be allowed, and a direction is hereby issued to the respondents to pay the petitioner's salary from the date of his appointment as a lecturer as per the Government of Karnataka pay scales till he attained the age of superannuation. The petitioner would also be entitled for all retirement benefits that a government servant would be entitled to, commensurate with the post that the petitioner held. Petition is accordingly allowed. This order shall be completed within a period of 3 months from the date of receipt of a copy of this order.
Obliged.
Seal number 3.
My lord, I am for petitioner, my lord.
Yes.
Last hearing, lordship directed to the respondent government advocate to file the affidavit.
Yen, madam?
Lordship, since the principal secretary is out of country, my submission is to the chief engineer South is the appointing authority. If Lordship direct the chief engineer South PW to file an affidavit by next date of hearing, I will comply the order.
The principal secretary.
A specific principal secretary has filed an affidavit for seeking time to file the affidavit, the adjournment. But for this D group employee, Lordship, the chief engineer South PWD is the appointing authority.
When is the principal secretary coming back?
By 9th, he will be back, Lord.
Released on 11th.
After 11th, 16th, Lordship, again session is there that week. Week after next.
16th, by which time? The order dated 25/9/2024, which requires the principal secretary to file an affidavit.
Lordship, can it modify, the chief secretary can file, he can file the affidavit.
Principal secretary or anybody above him.
Obliged.
Please.
Number 4, Shri Ravi B. Patil.
This is the matter pertaining to the University of Agriculture Science.
anomaly regarding the difference in the cadre of typist and stenographers. Your Lordship, and the proposed
Lordship, my bad, it only the affidavits need to be signed to file an objection. Maybe taken up on 16th. Finally, it will be filed and argued.
No, last date compliance. They have to simple. One way time.
ಏನ್ ಮೇಡಮ್ ನಿಮ್ದು?
Objections ready, this are affidavit sign ಆಗ್ಬೇಕಾಗಿದೆ one day.
ಇಲ್ಲ affidavit
Finally,
last they had filed an affidavit on
affidavit ಇದೆ, the objections ಹಾಕಿಲ್ಲ. Only the as per the direction of the honorable court, affidavit was filed with only with regard to the approval of the C&R. The detailed objections are ready. I will file.
the role of government is very minimal, under section 53 of the act.
Akli. You can't prevent them. Relist.
ಇಲ್ಲ ಅವ್ರ ಮುಂಚೆ ಒಂದು statement of objection ಇದೆ. They have filed detailed.
ಇಲ್ಲ ಅಂದ್ರು. She said she wants to file objections. Let her file objections. I'll take it up next week. Relist.
Next my lord.
Next Friday.
Oblige.
See number 5. Chakashetty.
Serial number 9, my lords.
5, madam.
Sorry, my lords.
Lord, I appeal for the Lord, respondent number 5, University.
Yes.
Lord, today I have filed Lord case compilation in the counter, and also Lord, I have given Lord PDF copy, Lord, scanned copy to the Lord concerned officer here in probably Lord maybe access to that. Otherwise, Lord.
Citations are.
House, sir.
Ready na ನೀವು?
On behalf of University, I am ready, Lord.
Madam.
Lordship, I am also ready since the Lordship has directed the respondent to file the staff pattern that along with the memo I have filed already.
ಯಾವಾಗ?
Lordship, it was already filed on 19/10/24 and I have inquired with the registry also. They say that it has been communicated to the Lordship.
What is the matter about?
Let us regarding regularization of the professors, assistant professors in the university, Karnataka, Gulbarga University. The petitioners are appointed in the year 2003 as a guest lecturers.
2003.
Yes, please.
You have the appointment orders with you?
I have produced them. Service certificate is issued by the university. Those service certificate is produced along with merit petition annexure D. It is Dr. Ansuya.
Petitioners session. Petitioners.
Three persons. Three.
When was P1 appointed?
First petitioner, serial number 42, serial number service certificate is produced. She appointed in the year 2000. Notice 2003.
Page number.
Please. Page number 42, service certificate.
Ansuya Kadam ante ide yado Uday Kumar anta ide.
First petitioner Ansuya Kadam, Dr. Ansuya Kadam. Petitioner number 1, serial number 42. Sorry.
Serial number 42.
Sorry, the page number 42.
42 relates to Uday Kumar.
The writ petition, two writ petitions,
200458.
2687.
They are the 200458.
Same. Both the person. One they issued the at that 2002 they have issued the notification for appointing the guest lectures. That notification I have challenged.
We'll take up first to the first petition 200458 by 2023.
Please.
Adu nimde tane?
Yes, both.
First petition yavaga appoint agita? Ready ilva ನೀವು?
Ready? This synopsis I'll produce later. Sixth.
See number 6. The Ganesh Upasana.
Seal number 6.
Seal number 6.
Your Lordships, I'm appearing. Your Lordships, I seek for a week's adjournment in this matter, Your Lordships. The council, there is someone passed away in council's home, Your Lordship.
Relist.
Obliged, Your Lordships.
For further hearing, seal number 7, Shri Ravindra Reddy. Shri Ravindra Reddy, seal number 7.
Madam, 7, 8, 9 ಎಲ್ಲ ಒಂದೇ ತಾನೆ?
Lordship. 7, 8, the one of the contesting respondent is CMC Shahabad, Lordship.
ಅಲ್ಲ 7, 8 and 9 are all relating to regularization ತಾನೆ?
Yes, yes, all subject matters are with regularizations.
Ready ತಾನೆ? Ready ನಾ?
ಇಲ್ಲ ಸರ್, ಡಬಲ್ ಏಜ್ ಅವರೇ ಬರ್ತೀನಿ ಅಂದಿದ್ದಾರೆ. ಬಟ್ ಬ್ಯಾಚ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಫೈಲ್ ಆಗಿದೆ ಸರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 9
ಮಾಡಿ ಈಗ ಮಾಡ್ತೀರಾ ಇವತ್ತು?
ಇಲ್ಲ, he says he will appear. ಬರ್ತಾರೆ ಸರ್ ಡಬಲ್ ಏಜ್. ಡೆಫಿನೆಟ್ಲಿ ಬೈ ಬಿಫೋರ್ ವೆಕೇಶನ್ ಇಟ್ ವಿಲ್ ಬಿ we will conclude our
next Friday.
No, week after next. Final.
Relist. Seven, 8.
List number 1, passed over matters. Seal number 37.
Time ತಗೊಂಡು.
Your Lordship, senior is on the Your Lordship. Senior is coming, Your Lordship.
Can't hear you.
Your Lordship, senior is coming, Your Lordship.
Senior is?
Coming, Your Lordship.
ಬೆಳಗ್ಗೆನೂ ಕರೆದ ಯಾರು ಬರಲಿಲ್ಲ. ಬಸು.
Seal number 40.
I pay for the respondent. She's appearing for respondent number 5 million.
For transfer of this original suit pending in Nalamangala Civil Judges Court, the district court where the probate proceedings are pending.
Which was the first suit?
First suit is the suit filed before the Civil Judges Court.
Nelamangala.
Nelamangala.
And that is in the year 2013.
Yes.
Okay,
problem is this, my lord, an application was filed under section 276 of Indian Succession Act for converting this probate proceedings as a original suit proceeding. But because of the full bench judgment of this honorable court, it cannot be done. So that application came to be dismissed. So the alternative left is at least take this matter to that court, because the probate proceedings cannot be transferred to principal civil judges court. First suit.
Not after, I can't grant this after so many years. 7 years.
Lord, this probate proceedings are initiated in 2022. In
2013.
Suit is filed in 2013.
For 10 years if you participate. And now you say no.
No. My contention is, your lordship may kindly appreciate, the probate proceedings are initiated in the year 2022.
Yes, you should have initiated this proceeding much earlier.
I am not the petitioner in that.
Why are you worried?
Conflicting.
That petitioner is not interested in transfer.
The issues in OS and P&SC are one and the same.
Ask them to stay the proceedings till it is disposed of.
ಎಲ್ಲ ಯಾಕೆಂದ್ರೆ this is
The petitioner in P&SC is not before this court.
no,
He is
they
not-
are
The petitioner in P&SC is not before this.
he is the respondent.
Respondent ಕೇಳಕ್ಕಾಗಲ್ಲ ಟ್ರಾನ್ಸ್ಫರ್. petitioner ಒಂದು ಕೇಳಿದ್ರೆ ಒಪ್ಕೊಳ್ತೀನಿ. ನಿಮ್ಗೇನ್ ಇಂಟ್ರೆಸ್ಟ್ ಇರುತ್ತೆ?
The contention is that they are claiming the property by virtue of a will, which is being disputed by the plaintiffs in the original suit.
They suffer the consequences. Why are you worried?
That's conflicting.
ನಿಮ್ಗೆ ಯಾಕೆ ಅವರೇ ಸುಮ್ಮನೆ ಇದಾರೆ, ನೀವ್ ಯಾಕೆ ಕೋ ಡಿಫೆಂಡೆಂಟ್ ಗೆ ಎಷ್ಟೊಂದು ಇದು ಮಾಡ್ತೀರಾ?
ಆಗಲ್ಲ.
This petition is filed seeking.
ಅಲ್ಲಲ್ಲ, your lordship may kindly ಇವಾಗ decision court can try this.
You cannot argue on behalf of the petitioner in P&SC.
I am not arguing on behalf of the P&SC. I am the plaintiff in I am arguing on behalf of the plaintiffs in the suit. Conflict of interest.
ಯಾಕೆ ಏನ್ ಬರ್ ಕಾನ್ಫ್ಲಿಕ್ಟ್?
See, they have raised same issues. ಇದ್ರಲ್ಲಿ ಒಂಥರ ಜಜ್ಮೆಂಟ್, ಅದ್ರಲ್ಲಿ ಒಂಥರ inconsistency would come. Inconsistency would come. So my only endeavor is let both these matters be tried before a same judge.
You are not claiming under the will.
I am not claiming, I am opposing the will.
So therefore you go on with the suit. If he has not proved the will in accordance with law, he will suffer the consequences. Why are you arguing on his behalf?
I am not arguing on behalf of the petitioners in the probate proceedings. See, they are making the claim that they are entitled to succeed as a legatee under the will. So, proving the will here and there, why? Therefore,
I am not inclined to transfer it now. ವಿಡ್ರಾ ಮಾಡ್ಕೊಡಿ, ಇಲ್ಲ ಅಂದ್ರೆ
I'll just consult and make.
Madam, the petitioner is the plaintiff, alva?
Plaintiff in the OS 124 of 23.
In OS 2013, which has been instituted before the third additional senior civil judge in JMFC at Nanmangla. He is seeking for transfer.
This matter may be taken up some other day.
Transfer of P&SC number 28/2022, which has been filed by which respondent? Filed by
2, 4 and 5.
2, 4 and
respondents 2, 4 and 5. Yes. To the second additional district and session judge, Bangalore Rural District, where it has been instituted. It's correct. In my view, in the light of the fact that the suit OS number 124/2013 has been pending consideration for almost 11 years and is now at the stage of arguments.
Evidence has come out because of so many other problems.
There is no justification for transfer.
ಅಲ್ಲ, ಎರಡರಲ್ಲೂ evidence comments ಆಗಿಲ್ಲ.
28/22 at the instance of the petitioner. Petitioner is therefore dismissed.
Much obliged.
Finally, reading matters. Seal number 74. Gopal.
Petitioner. I am the purchaser of the land. Land granted 18th February 1963. Non-alienation period for 15 years, please.
Date?
Sailed
1863.
1963. For non-alienation period of 15 years. Sale deed executed by the executed on 18th February 91. After the lapse of 32 years, they have questioned, please.
But after the act came into force.
Please.
Yes. Court permission illa.
ಇಲ್ಲ ಪರ್ಮಿಷನ್ ಇಲ್ಲ ಸರ್.
ಇಲ್ಲ.
But 32 years ಆಗಿದೆ.
When was the applicable resumption filed?
Resumption during 20th July 2010, please. Report submitted by the Tahsildar.
After 30 years.
30 years, please.
30 years.
30 years, please.
I've gone through the facts just now. I'll ask my seniors.
Provision.
We'll argue.
Not within the reasonable time, please.
List.
Fix number 75.
Great.
Camping order. appear for R4, my lord.
ಒಂದ್ಸಲ DNP ಮಾಡಿದ್ದೆ. DNP ಮಾಡಿದ್ದೆ.
ಮಾಡಿ ಅವರ ರಿಕ್ವೆಸ್ಟ್ ಮೇಲೆ ಮತ್ತೆ ರೆಸ್ಟೋರ್ ಆಗಿತ್ತು.
Also.
Number 76, SV Prakash.
Prakash.
SV Prakash. Number 77, Shri.
Recently, 26/11 ನಾವು filed the NOC ವಕಾಲತ್ ಮಾಡಿದೆ. ಅಲ್ಲಿ ಅದರಲ್ಲಿ that what happened was that other
ಯಾವಾಗ ತೀರೋದ್ರು?
that next week ಮಾಡಿದೆ.
ಯಾವಾಗ ತೀರೋದ್ರು?
ಅವರು ತೀರೋಗಿರೋದು that 1A ಮಾಡಿದೆ died on 17/7/2023 ಮಾಡಿದೆ and 1D died on 4/6/2021 ಮಾಡಿದೆ. And only that 1B and 1C are available ಮಾಡಿದೆ. I filed the NOC ವಕಾಲತ್ ಮಾಡಿದೆ. So your lordship may kindly next week ಮಾಡಿದೆ I will mean discuss the arguments on merits ಮಾಡಿದೆ.
List.
78 adjourned. See number 79, Shri Chandranath Hariga.
My lord, yesterday I was held up in some other. That's it. My lord, here is a case where the date of grant is not available in the records. Because according to the petitioners, my lord, the year of grant is 52-53.
According to the petitioner.
According to the petitioners, the deputy commissioner holds that it must have been during the period 1931. Holding that it is during the period of 1931, first alienation was in the year 1969. It is beyond 20 years. Therefore, the deputy commissioner holds that the alienation is beyond the period. Therefore, it is not hit by section 4. I have one submission to make. Kindly take section 4 for a minute. Subsection 2 of section 4.
Yes.
Because the no person shall, after the commencement of this act, transfer or acquire by transfer any granted land without the previous permission of the government. That is permission from the state. The second sale was on.
First sale is valid.
First sale is, whether first sale
They are
is.
only concerned with the first sale, not with the subsequent.
Yes,
sales.
yes, ma'am. Because first sale also, whether it is 1952, 53 or 1931, 32, Sagwali cheat is not available. The
And
deputy.
on what basis do you say it is 52, 53? You are the grantee.
I am the plaintiff, I am the petitioner.
You don't know the date of the grant.
The date of grant, because they don't have the records.
No, you, on what basis are you
Yes,
alleging that?
that is, my lord, kindly see the order of the Assistant Commissioner at page 40.
Page?
Page 40.
Yes.
40.
Page 41, ದಾಖಲಾತಿಗಳ ಪರಿಶೀಲನೆ.
ಹೌದು. Annexure E, the ಅರ್ಜಿದಾರರ ಪರ ಸಲ್ಲಿಸಿದ ಲಿಖಿತವಾದ ಮಂಡನೆ.
Let us read from ದಾಖಲಾತಿಗಳ ಪರಿಶೀಲನೆ.
ಎಲ್ಲಿ?
Next page, page 41.
Yes.
ದಾಖಲಾತಿಗಳ ಪರಿಶೀಲನೆ.
ದಾಖಲಾತಿಗಳ ಪರಿಶೀಲನೆ. ಎಸ್. ಸದರಿ ಪ್ರಕರಣವನ್ನು 24/6/2014 4/9/2020 ವಿಚಾರಣೆ ನಡೆಸಲಾಯಿತು. ಸದರಿ ಪ್ರಕರಣಕ್ಕೆ ಸಲ್ಲಿಸಲಾಗಿರುವ ಎಲ್ಲಾ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಪ್ರಶ್ನಿತ ಜಮೀನು ಚಳ್ಳಕೆರೆ ತಾಲೂಕು ಕಸ್ಬಾ ಹುಬ್ಳಿ ಸೋ ಸರ್ವೆ ನಂಬರ್ 275 ಹೊಸ ಸರ್ವೆ ನಂಬರ್ 322ರಲ್ಲಿ 4 ಎಕರೆ 38 ಗುಂಟೆ ಜಮೀನು ದರಖಾಸ್ತು ಮೂಲಕ ಬಂಗ್ಲಿ ತಿಮ್ಮಯ್ಯ ಬಿನ್ ಚಳ್ಳಕೆರೆ ಇವರಿಗೆ ಮಂಜೂರಾಗಿದ್ದು ಇವರು ಆದಿ ಕರ್ನಾಟಕ ಜಾತಿಗೆ ಸೇರಿರುತ್ತಾರೆ. ಮೂಲ ಮಂಜೂದಾರರಿಂದ SR ನಂಬರ್ 15446869 ದಿನಾಂಕ 15/2/69ರಲ್ಲಿ ಗಿರಿಯಪ್ಪ ಬಿನ್ ಇವರಿಗೆ ಕ್ರಯವಾಗಿರುತ್ತದೆ. ಬಿನ್ ವೀರಭದ್ರಪ್ಪ ಇವರಿಗೆ ಕ್ರಯವಾಗಿರುತ್ತದೆ. ನಂತರ ಗಿರಿಯಪ್ಪ ಮತ್ತು ಮಕ್ಕಳು ಸೇರಿ ಸೋ ದಿನಾಂಕ 14/2/86ರಲ್ಲಿ ಶ್ರೀಮತಿ ಪುಷ್ಪಾ ಬಿನ್ ಹನುಮಂತಪ್ಪ ಇವರ ಹೆಸರಿಗೆ ಕ್ರಯವಾಗಿರುತ್ತೆಂದು ತಹಶೀಲ್ದಾರ್ ಚಳ್ಳಕೆರೆ ಇವರು ವರದಿ ನೀಡಿರುತ್ತಾರೆ. ಪ್ರಶ್ನಿತ ಜಮೀನು ವೆಂಕಟೇಶಪ್ಪ ಬಿನ್ ಅನಂತಪ್ಪ ಇವರ ಹೆಸರಿಗೆ ಇರುವುದು ಪಹಣಿ ದಾಖಲೆಯಿಂದ ಕಂಡುಬರುತ್ತದೆ. 1ನೇ ಮತ್ತು 2ನೇ ಪ್ರತಿವಾದಿಗಳಿಗೆ 26/2/2014 ಶೋಕಾಸ್ ನೋಟಿಸ್ ನೀಡಲಾಗಿರುತ್ತದೆ. ವೆಂಕಟೇಶಪ್ಪ ಬಿನ್ ಅನಂತಪ್ಪ 2ನೇ ಪ್ರತಿವಾದಿ ಹಾಗೂ ಹಾಲಿ ಪಹಣಿ ದಾಖಲೆ ಇರುವ ಜಾರಿ ಮಾಡಲಾಗಿದೆ. ತದನಂತರ 24/2/2014 ಪ್ರತಿವಾದಿಗಳ ಪರವಾಗಿ ವಕಾಲತ್ತು ಹಾಕಿರುತ್ತಾರೆ. ಆದರೆ ಅಂದಿನಿಂದ ಇಲ್ಲಿಯವರೆಗೂ ನ್ಯಾಯಾಲಯದ ಕಲಾಪಗಳು ನಡೆದು ಸಾಕಷ್ಟು ಬಾರಿ ನೋಟಿಸ್ ನೀಡಲಾಗಿದೆ. ಆದರೆ ಯಾವ ಹಂತದಲ್ಲಿಯೂ ಪ್ರತಿವಾದಿಗಳು ಗೈರು ಹಾಜರಾಗಿ ಅರ್ಜಿದಾರರ ಲಿಖಿತವಾದಕ್ಕೆ ಯಾವುದೇ ಆಕ್ಷೇಪಣೆಯನ್ನು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ದೆನ್ ಸದರಿ ಪ್ರಕರಣವನ್ನು ವಿಶ್ಲೇಷಿಸಿದಾಗ ಈ ಕೆಳಗಿನ ಪ್ರಶ್ನೆಗಳು ಹೇಳುತ್ತವೆ. ಪ್ರಶ್ನಿತ ಜಮೀನು ಸರ್ಕಾರದಿಂದ ಮಂಜೂರಾದ ಜಮೀನೇ? ಹೌದು, ಸರ್ಕಾರದಿಂದ ಮಂಜೂರಾದ ಜಮೀನು. ತಹಶೀಲ್ದಾರ್ ಚಳ್ಳಕೆರೆ ಇವರು ಪತ್ರ ದಿನಾಂಕ 5/12/2013 ನೀಡಿರುವ ವರದಿಯಿಂದ ಕಂಡುಬರುತ್ತದೆ. ಸದರಿ ಜಮೀನು ಮೂಲತಃ ಅರ್ಜಿದಾರರು ಬಂಗ್ಲಿ ತಿಮ್ಮಯ್ಯ ಬಿನ್ ಚಳ್ಳಕೆರೆಯನ್ನವರಿಗೆ ಮಂಜೂರಾಗಿರುವುದು ತಹಶೀಲ್ದಾರ್ ಪತ್ರದಲ್ಲಿ ತಿಳಿಸಿರುತ್ತದೆ. ಆದರೆ ಮೂಲ ಕಡತ ಲಭ್ಯವಿಲ್ಲದ ಕಾರಣ ಸಾಗುವಳಿ ಚೀಟು, ಡಿಮಾಂಡ್ ರಿಜಿಸ್ಟರ್ ಇವುಗಳನ್ನು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ಆದರೆ ಮಂಜೂರಾತಿ ಆಗಿರುವುದಕ್ಕೆ ಪೂರಕವಾಗಿ ದುರಸ್ತಿ ಆಗಿರುವ ಕಡತದ ನಕಲುಗಳನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಇದರಲ್ಲಿ ದಿನಾಂಕ 26/12/1931 ದರಖಾಸ್ತು ಪೋಡಿ ಆಗಿರುವ ಹೇಳಿಕೆ ಲಭ್ಯವಿದೆ ಹಾಗೂ ದುರಸ್ತಿ ಪೋಡಿ ಸ್ಕೆಚ್ ಲಭ್ಯವಿದೆ. ಪುಟ ಸಂಖ್ಯೆ 31ರಲ್ಲಿ ಸದರಿ ಜಮೀನು ಮಂಜೂರಾಗಿರುವುದು ಹಾಗೂ ಪೋಡಿ ಮಾಡಲು ಆದೇಶಿಸ ಇರುವುದಾಗಿ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಚಿತ್ರದುರ್ಗ ಇವರು ಶರಾ ಬರೆದು ಸಹಿ ಮಾಡಿರುವುದು ಕಂಡು ಬಂದಿದೆ. ಪುಟ ಸಂಖ್ಯೆ 55ರಲ್ಲಿ ರೆಸ್ಟ್ರಿಕ್ಟೆಡ್ ಟೆನ್ಯೂರ್ ರೂಲ್ಸ್ ಮೇರೆಗೆ ತಲಾ ₹4 ಕಟ್ಟಿಸಿಕೊಂಡು 26/12/1931ರಲ್ಲಿ ಮಂಜೂರು ಮಾಡಲಾಗಿದೆ ಎಂಬ ಉಲ್ಲೇಖವಿದೆ. ತದನಂತರ ಸಾಗುವಳಿ ಚೀಟು ನೀಡಿ ಜಮೀನು ದುರಸ್ತಿಯಾಗಿ ಸರ್ವೆ ನಂಬರ್ 275 ಹೊಸ ಸರ್ವೆ ನಂಬರ್ 322 ಪೋಡಾಗಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಆದರೆ ಸಾಗುವಳಿ ಚೀಟಿ ಶಿಥಿಲವಾಗಿ ಲಭ್ಯವಿರುವುದಿಲ್ಲ. ಮಂಜೂರಾತಿ ಹಾಗೂ ಸಾಗುವಳಿ ಚೀಟಿ ವಿವರಿಸಿದ ನಂತರವೇ ಪೋಡು ಮಾಡಲಾಗುತ್ತದೆ. ಈ ಎಲ್ಲಾ ಪೂರಕ ದಾಖಲೆಗಳಿಂದ
The finding is as per the records relating to Durasti, there is a reference to a grant of the year 31.
appears to
Dated
be
26/12/1931.
ಅಲ್ಲಿ ಮಂಜೂರು ಮಾಡಲಾಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದಕ್ಕೆ ಉಲ್ಲೇಖವಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಯಾವುದು ರೆಕಾರ್ಡ್ ಇದರಲ್ಲಿ ಇರ್ಲಿಲ್ಲ. ಇಲ್ಲ.
But ಇದೆಯಲ್ಲ, he has referred to the Durasti proceedings.
ಅಲ್ಲ,
This is a
ಅದಕ್ಕೆ
clear reference to the grant of the year 31. The property is sold in the year 69.
Property, yes, my lord, there is not 69, actually before that 66, there was a transaction that has come.
But even then it is,
Yes, but ಸಾಗುವಳಿ ಚೀಟು ಲಭ್ಯವಿಲ್ಲದ ಪ್ರಕಾರ, yes, that's, and when
if you have something to show the land was granted in 52, that is one thing. On the basis, you can't choose the date of the grant.
I cannot, how can I, against the records, how can I? But through
That has been affirmed by the deputy commissioner.
No, here it is.
AC order is in his favor.
Assistant Commissioner holds that ಅರ್ಜಿದಾರರ ಅರ್ಜಿಯನ್ನು ಪುರಸ್ಕರಿಸಿದೆ.
Notwithstanding the fact that the alienation was made beyond 20 years, he has passed an order of resumption.
He has ordered for resumption. The Deputy Commissioner has reversed it, holding that it must be in the year 1930 granted.
Even the
Because
assistant commissioner records the same finding.
no, Assistant Commissioner, she says appears to be 1931, there is no.
He's categorical. He says, on the basis of the records available for Durasti, there's a clear reference to the order, and he also gives a date.
26/12/1931 ಎಂಬ ಉಲ್ಲೇಖವಿದೆ.
ಉಲ್ಲೇಖವಿದೆ ತದನಂತರ ಸಾಗುವಳಿ ಚೀಟಿ ನೀಡಿ ದುರಸ್ತಿಯಾದ. So he's specific on the basis of the subsequent records.
That is
sure that it was made on 26/12/31.
And it is ported ಅಂತ ಹೇಳ್ತಾರೆ. 275 is ported. And Deputy Commissioner, I know that it is a feeble attempt on my part to get over the Deputy Commissioners.
After 69, after how many 50 years, what is the point?
It's about 33 years, no, 50 years.
Date of the sale ತಗೊಂಡ್ರೆ.
After that, yes, date of sale is 15/2/1969. 15
Let
to
it rest.
60.
You lost the land 50 years ago. ಇನ್ಯಾಕೆ ಅದು?
ಅಲ್ಲ, annexure ಏನಲ್ಲ, Lakshmi Kandis annexure A. This is the representation given by them on 6/7/1933.
No, I have placed it on record because it is available on the record.
ಅಲ್ಲ, ಅದಕ್ಕೇನೆ they themselves admit ಇದು representation 33 ಕೊಟ್ಟಿರೋದು.
ಅಷ್ಟೇ ಅಲ್ವಾ?
Page 15 ಅಲ್ಲಿ they admit it was
Application for resumption was made by the elders of the grantee.
At least
In the
an
proceedings.
attempt to get it remanded so that Sagoli chit, if we can.
In
ಇದ್ರೂ
these proceedings of the assistant commissioner.
full bench ಪ್ರಕಾರ taking possession.
The assistant commissioner has
33.
recorded a clear finding that though the original land grant records were unavailable, he has nevertheless looked into the Durasti proceedings in which there was a clear reference to an order of grant made on 26/12/1931. Despite giving a finding that the land was granted in 26/12/1931, the assistant commissioner proceeded to pass an order of resumption, taking into consideration the second alienation that was made in the year 86.
Yes.
The purchasers preferred an appeal to the deputy commissioner. Deputy commissioner, on taking note of the fact recorded by the assistant commissioner that the grant was made on 23/12/26/23, na? What was the date of the assistant commissioner? 26?
Assistant Commissioner's order is on
18/18/31.
Yes,
As
1931.
concluded that the first alienation was made beyond the period of 20 years, that is in the year 1969, and therefore there was no question of violating any of the terms of the grant. He has also recorded a finding that as per the then prevailing rules of the year 1931, the period of non-alienation was only 20 years. And since the alienation was made after 20 years, the provision of the PD's right could not be invoked. Next one. It is also noticed that as per Annexure A, the petitioners themselves admit that the grant was made in their favor on 26/12/1931. So it is therefore clear that the land in question had been granted on 26/12/1931, and as a consequence, the period of non-alienation would only be 20 years. So since admittedly the first alienation was made in the year 1961-69, that is nearly after a period of 28 years.
38 years.
38 years, comma. The question of there being a violation of the terms of the grant, enabling the grantee to invoke the provisions of PTCL Act would not arise. So, in my view, both the authorities, having concluded that the grant was made in the year 31 and the alienation was made beyond the period of 20 years prescribed, as on the date the grant was made, comma, there is no justification rendered in this petition. Petition is therefore dismissed.
Passed over matters, bill number 37. Okay for the petition.
Your Lordship, I am for the respondent, Your Lordship. Senior is held up in court also awaiting Your Lordship. I seek time, Your Lordship.
They were supposed to submit make some statements
short
based on
application.
records.
The time by control.
They requested for Tuesday minutes.
Next.
List sixth. Please.
Grateful.
Bill number 75.
75.
Prakash.
The last occasion, the respond directed to secure some documents regarding the last occasion, directed to
Application ನೀವು ಬರ್ಲಿಲ್ಲ ವಜಾ ಮಾಡಿದ್ದೆ ಆಮೇಲೆ ತಿರ್ಗಾ ಬಂದು ಮೆನ್ಷನ್ ಮಾಡಿದ್ರೆ
please earlier occasion, the
ಏನ್ ಮ್ಯಾಟ್ರ್ ಏನು?
CST, I am the purchaser of the property. Purchaser of the property. And delay 9 years delay, the delay is not recoverable.
ಯಾವತ್ ಗ್ರಾಂಟ್ ಆಗಿದೆ ಯಾವಾಗ?
The grant,
7/6/1980.
98.
98.
Please.
7/6/1980.
After the act came into force.
Yes.
Commission order ಅಲ್ಲಿ
Commissioner.
Page number
next
37.
ಯಾವುದು annexure?
23/7/2011.
Annexure ಹೇಳಿ.
Assistant Commissioner.
Yes. Annexure D.
Annexure D.
Page number 24.
24. Twenty-four is. I will get it.
ಮತ್ತೆ fill ಆಗ್ತದೆ.
The assistant commissioner doubted that he belonged to scheduled caste.
Yes.
Please.
Next.
Then what happened to the deputy commissioner?
The respondent has filed an appeal and before the deputy commissioner. The deputy commissioner has remanded the matter. The school certificate and other record pursue the records.
Where is the order passed on remand?
Remand on 20 next year. And later. Next year, my lord.
Next year,
E.
Page 28.
Page-
this is 2009. This is the order of remand.
Yes.
Remand admile ಏನಾಯ್ತು?
Thereafter, assistant commissioner is restore the matter, allowed the application and restore the land. Then the petitioner has filed an appeal before the deputy commissioner. The deputy commissioner is dismissed the appeal. (23/7/2011). Appellant 15/12/2014. Annexure H. Deputy Commissioner order. Page 51-53.
Page number 44. Your Lordship.
Where is the order of the DC?
DC order, my lord.
DC order.
Page number
Page
51.
44, Your Lordship, that the second
Course.
paragraph.
The-
Page 44.
DC order, madam.
DC order.
DC order, page number 51, my lord. Annexure H.
Annexure
H. Annexure H. 15/12/2014 order.
42.
Okay. Okay.
Yes.
I'm
ಏನ್
9 years delay, my lord. I'm the purchase of the property, my lord.
No, no, no.
5 years is nothing.
Already, yeah, I purchased the property and developed the lands also, my lord. I taken the electricity connection also, my lord.
ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
Nine- 19 one submission.
At this stage, my lord, it's a 9 years delay is there, my lord. The Supreme,
The land was granted after 79.
please,
What is the period of non-alienation?
15 years.
And you are aware that you should take permission under 4(2). You have not taken permission. What is that can be done?
It is true, my lord, but the earlier, my lord, the 9 years delay, that is,
9 years is not.
ಇಲ್ಲ, ನಮ್ಮ
I have taken the property and purchased the developers, my lord. I cite one decision, my lord.
ಏನ್ ಬೇಡ.
It's a delay, my lord. The delay is not curable defect, my lord.
Delay ಬರಲ್ಲ ಇದರಲ್ಲಿ. This is after the act came into
I
force.
purchased property from 1995, my lord.
Correct.
So 15 years,
This is after the act came into force.
please,
The land itself is granted after the act came into force.
please. But my lord, difficulty is, my lord,
The petitioner is the purchaser.
for a moment, my lord. Kindly tomorrow, my lord. Kindly tomorrow, one day accommodation, my lord. I approach the party, my lord.
Application for.
Kindly, my lord. I have
ಏನ್
to,
ಮಾಡ್ತೀರಾ ನಾಳೆಗೆ?
tomorrow, my lord, party ಒಂದ್ಸಲ ಕೇಳ್ಬಿಡ್ತೀನಿ.
ನಾನು ಅವ್ರು ವಜಾ ಮಾಡಿದ್ರೆ ವಜಾ
ಅಲ್ಲ,
ಮಾಡಲ್ಲ.
ಹಂಗೆಲ್ಲ ಅದು that is not my intention, my lord. Senior also is,
ನೀವಿದಿರಲ್ಲ ಸಾಕ್ಬಿಡಿ.
ಅದಕ್ಕೋಸ್ಕರ ನಾಳೆ ಒಂದ್ ದಿವಸ ಅಕಾಮಿಡೇಷನ್ ಮಾಡಿ. ನಾನು I will.
ಮಂಡೇ ಆರ್ಡರ್ಸ್.
Please.
ನೀವು 10:15 ಬರ್ಲಿಲ್ಲ.
ಇಲ್ಲ, before 10:30 I will appear.
ಆಗ್ಬೋದು ಅಂತ.
Before agreement ಮಾಡ್ತಿಲ್ಲ. ಸರಿ,
ಏನು ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ.
Tuesday excellent. Then March, politics.
ಮೇಡಮ್ ನೀವು ಅಲ್ಲಿ ಮೂವ್ ಮಾಡಿದ್ರೆ ಅವರು ಹಾಕಿರೋ ಹೌದು ನೀವು ಡೈರೆಕ್ಟ್ ಆಗಿ ಇಲ್ಲಿ ಮೂವ್ ಮಾಡಿದ್ರಿ ಸೊ ಅದು ರಾಂಗ್ ಮೂಡ್ ಅಂತ ಅವರು ರಾಂಗ್ ಮೂಡ್ ಹಂಗೆ
ಅವರು ಅಲ್ಲಿ ಕಳ್ಸೋದೇ ಇಲ್ಲ. 2:30 ಇಲ್ಲೇ ಮಾಡಿ.
ನೀವು ಅಲ್ಲಿ ಹೇಳ್ಬಿಟ್ಟು ಯಾರಿಗಾನ ಮೆನ್ಷನ್ ಮಾಡಿಸ್ಬಿಟ್ಟು ಹೇಳಿದ್ರ
ಈಗ ಮಂಡೇ
ಲಿಸ್ಟ್ 3 ಎಲ್ಲ ಫ್ರೈಡೆ ರೆಗ್ಯುಲರ್ ಬೆಂಚ್
One week ಅಂತ after 1 week ಅಂದ್ರೆ ಸರ್ ಸೀರಿಯಲ್